My lord, court is not audible, my lord.
Yes, next.
All objections.
Call the list.
Page-wise adjournments. List 1.
My lordship, serial number 20.
Page number.
Both side advocates are present. May kindly be refer the mediation parties are ready to settle the matter.
Let
Please.
her call.
Page-wise adjournment. List number 1. Page number 3. Serial number 9 to 11.
Serial number 11. I am for the petition in both the connected matters. The counsel on record is not doing well. I'll have to have it.
Have you informed others?
Yes, I've informed the others. They have been.
At request, this is matter after vacation.
Great.
Counsel for the petitioner. Yes.
Page number 4. Serial number 10 to 17. Page number 5.
Well, at 17, the matter may be referred for mediation. There may be a chance of settlement.
Where is the other side?
Rama Raya.
Present.
It can be referred.
We don't have any objections for mediation.
It is submitted with the likelihood of settlement. Where are the parties?
Parties are in Bangalore.
Bangalore. The party shall appear before the here or Bangalore Mediation Center.
Bangalore
Mediation Center. Yes. Shall appear on 2nd of September. No, October. Not 2nd. 25th of September. Yes. Yes.
Page number 5. Serial number 18 to 20.
Serial number 19, your ladyship. This matter was posted on the 8th of October. In my absence, they have moved a memo. They have not filed any application. I am in the process of producing certain documents. It will be taken on the regular date.
Have you informed the other side?
Which one?
I have not informed the other
Then
side. The regular.
please wait till the matter is called. Yes.
Serial number
Yes.
20, my lord.
Page number 6.
Serial number 20, I am for the petitioner, the counsel for respondent also present. My parties are ready to settle the matters. May kindly be refer the matter before the mediation, family court.
Where? Here.
Family,
Right.
Bangalore.
Yes.
Mediation Center.
Bangalore Mediation Center. Give the date as 28th of October. Yes, next.
Serial number. Page number 6.
Short date may be fixing.
Short date.
Short date.
15.
24th September.
Great.
Yes.
Page number 6. Serial number 28 to 29. 28. List number 2. Page-wise adjournment. Page number 4. Serial number 10. Page number 5. 11, 12.
Lord,
Number
serial
My
serial
lord,
number 4 for mediation, my lords.
Serial number.
4, my lords. Lord, sir, in that the liability is fastened on the owner because there was an insurance lapse, sir. I have deposited the amount. Kindly refer the matter for mediation, my lords, sir. We will try to expect positive settlement, my lords.
Who is R3?
It's the insurance company.
And then we have to give notice. Then please wait. Please wait when the matter is called. That then we will do.
Please, my
my
lord.
lord, serial number 6. My lord. Serial number 6.
Yes.
My lord, my name will be deleted, my lord, in for respondent number 2.
Page number 5.
Please.
Serial number 11 to 11, 12. Page number 6. Serial number 13 to 16. Page number 7. Serial number 17 to 19.
My lords, serial number 19, my lords, kindly.
On the other side.
Yes.
I am
We'll
for
inform
the
now.
Not I
respondent number
will.
4.
Serial number 18, my lords.
Serial,
next.
1 second.
Let's-
sir.
Number 8. Serial number 20.
1 second. Sir.
List number 3.
Serial
One
number
minute.
19.
Serial number 18, my lords. Kindly a week's time may be granted, my lords.
Why?
Senior is not well, my lords. So.
Have you informed the other side?
Yes, my lords.
Serial number 19.
This is
my
matter in the
lords.
month of December. Yes.
List number 3. Page number 3. Serial number 10. Page number 4. Serial number 11 to 15. Page number 5. Serial number 16 to 19. Page list number 4 for referring to Lok Adalat matter. Serial number 1. Steps in respect of
No,
consent.
one delete from the list.
awaiting PCR.
One
that
minute,
is
one
locked.
minute.
Serial number 33.
Who is R3? R1.
R1 is Raja.
R1 is not Rajan.
Yes, ma'am. Lakshmi SV served. Be ready for R3. R1 is also incorrect.
This also delete. 3 also delete from the list.
Serial number 4. Also furnishing of PS in respect of
RT, this is 4 also delete. Post in the usual course.
Serial number 5. R1 to 3.
5 also delete. Remaining other matters, refer to Lok Adalat.
My lordship, serial number 10, my lordship, 10 and 11.
Hmm.
Settlement is not possible, my lordship.
Not
Liability
possible.
question, my
10
lordship.
and 11 also delete.
And 22, my lordship.
20?
2, my lordship.
22 also delete.
My lord, serial number 17, my lords. List
22
for
also
serial number
delete.
17. My
Yes.
lords, it has to be heard by this honorable court, my lords, because the
Yes,
liability is
delete.
much of it.
Yes, yes. Huh? Which is
7.
which item it is?
17.
Yes.
List number 5, serial number 2, my lord.
Huh?
List number 5, serial number 2, my lord.
5. That is at 2:30.
Yes.
List number 5, serial number 2. Place for 1 week time, my lord.
Let's see.
Sriram Delhi.
We'll see.
Page number 1. List number 1 for being spoken to serial number 1.
My lord, serial number, my lord, list number 5, my lord, not called, my lord. 7 and 8, I have some personal inconvenience. I have informed the other side also. List number 5. 7 and 8, my lord.
List these matters in the month of December.
Yes, ma'am. 7 and 8.
This 4, my lord.
Whenever you want, you just can't mention like that. It is already over. Please wait for your turn. This can't go on like this. Yes.
List number 1 for being spoken to serial number 1.
My
Lords, I
lords,
am the
recollect this
respondent.
matter.
I have
Lords.
moved the matter, my lords.
Let's hear what you
Yes.
say. Who has filed the for being spoken to?
My lords, I moved
Yes,
the memo,
what is
my
it?
lords. My lords, this matter, my lords, since the respondent has not disclosed their employment, my lords, the order was set aside and maintenance was not provided, though trial court has given, my lords. And in that, my lords, there was 18 months period where she was not at all employed. We have produced the proof along with the affidavit, my lords, that she was not employed.
Why the court was conscious of it? Why the court has not granted that?
No, my
Now
lords.
the court has to discuss everything and about and also court has to direct the trial court to initiate perjury proceedings against you if I have to discuss all those things. That's the reason I kept. If you want, court has absolutely no problem. I'll recall this order and I will record everything on the merits of it. Let your client, if the client is
Equity has sought.
no equity at all. No equity to a person who comes to
Equity
the court
cannot
with
be in
unclean
fraud.
hands. So if you want, ask your client. I will recall this order. I will record everything and I'll pass an order. That was the arrangement on that day. Yes.
Let that not.
This court do not find
Great.
any reasons to clarify the order. Yes, dismiss.
Grateful.
Yes, next.
Matters. Serial number 2. Shankar Reddy C.
My lord, we have served the hand summons to the respondent too, my lord. We'll file to in register today, my lord.
Hmm?
We'll file the copy served to the
that?
hand. We'll,
This is on 12/8/2025. Where are we now?
yes,
But then I'll vacate the interim order. There is an interim order.
no, no.
I will.
No, today we'll file to the register only, my lord. We have served the,
No, when if the memo is not filed by tomorrow, the writ petition stands dismissed.
Serial number 3. Aminullah. NK.
For respondent. The verifying affidavit is ready, well, file it.
Huh?
Affidavit is, there is a compliance for what? Objection. Madam.
What is the office objection on this? Statement?
Verifying affidavit has been not filed to the objections of the
You
respondent.
submitted that today. The verified affidavit will be filed.
Lords, there is a stay, there is an IF stay, my lords.
I am
He has
ready,
already-
my lordship, for argument. I am ready.
We'll hear the matter if you want.
Yes, my lords.
Yes. Yes, where is the impugned order? Impugned order,
Lords,
page number.
page number 33, my lords. $25,000 interim order has been passed, my lords. And they had filed a DV case where
First
20.
let me see the order. Where is the order? 33 is not the order. There are so many, on every page there are two numbers. One is in black ink, one is in blue ink. Which number has to be seen?
The blacking.
Sir, ಅದನ್ನು ಇದೇ ತಾನೇ type ಕೊಟ್ಟು. No.
25,000 is awarded.
Yes, my lords.
What is the income of the husband?
My lords, currently he is unemployed, my lords. From past 8 months, he is unemployed. And they had
When
filed
is
a
the order
DV.
passed?
My lords.
20th May 2024.
Yes, my lords.
Hmm.
He has paid 50,000, my lords.
When did you question this order? On 24/1/2025. So till 24/1/2025, you were working.
Yes, my lords.
So you have no objection to pay the maintenance till 24/1/2025 because you were employed, you were earning.
Yes, my lords. But they had filed a DV case, my lords. There,
That we'll go to that later. As far as your capacity is concerned, when you were working, what was your income?
my lords, it was about 1.5 lakhs.
1.5 lakh. So amount of 25,000 that is granted by the court, there is nothing to interfere with that till you lost your job on 1/1. When did you lose?
This year, in the beginning of this year, my lords. In the beginning of this year.
There is no date for that.
There's-
Okay. So where are the documents to show that you've lost your job?
Lords, I'll submit.
What you submit? When you're saying something, it should be supported by the documents. So basing on the material on record, there is nothing for this court to interfere with this order impugned.
No, my lords. Like he has paid 2 lakhs in the DV case, lords. My lord. 20 lakhs of the compensation, 2 lakhs he has paid, my lord. Again, now he has paid.
A person who
50,000.
has paid 2 lakhs compensation out of 20 lakhs that is awarded, you cannot say that this is not maintainable.
Lords, he has to pay the remaining amount also, my lord. That's a burden for him, my lord. As this situation, he has no job. My lord.
When was the order in the DV case?
Lords,
5th October, my lord. 5th October 2024. He is capable, my lord. I furnished all the documents, my lord. They had combined business, crores of rupees turnover has been.
my lord, that business
Paid,
is
my
not
lords.
his, my lords.
See,
He has
only one
nothing to
son,
do
my
with the
lordship.
business, whatever they are saying. It's
I have produced all the documents, my lord.
Where are
Satisfied copies, my lordship. Page number 1, it is salary slip of the petitioner. Page number 22 to 27 of my objections, my lordship. Salary slip clearly states that 16,38,640 rupees.
1 minute. When is this order? When is this document? What is
That
the
is
date of the
2021, my lord.
In my objections, my lordship.
I'm seeing your objections only.
It is
22 page, what is the date?
the 2021, my lordship.
Then what is the 24?
22 to 24, my lordship.
Then
My lordship, 27, my lordship. He is holding PF account, my lordship. PPF account with his father, my lordship. And page number 36, 37 is syndicate bank account, my lordship. 38 to 42 HDFC bank, my lordship. 43
First of all, you're referring to one bank account. I have to see or not?
Yes, my lord.
What is to be seen in that account? That you have to point out.
My lordship. It is salary slip, my lord. Page number 23, my lord.
Page number?
Page number 23, my lordship.
Running page, you have to tell the running page. It is starting at page number 30. Your documents are at 30. The bank account.
A bank account is 30, my lord.
That's why the office has raised their objections. What are these numbers? I'm not able to follow none of these. Please look at your document. What is the pagination you have given? This is matter after vacation. Yes. Office shall verify the page numbers in the objections, that is the document that are filed along with the objections. Yes,
After vacation, my lord.
after vacation.
Much obliged.
Serial number 4. Magesh Vinay, yes.
So I'm the respondent, my lordship.
Sudarshan.
Appear for petitioner, my lord. My
This-
lordship, I would like to submit an affidavit detailing how I am equipped.
Not required. Yes, what are your,
This matter was earlier disposed of, my lord. Now we have filed review petition. My respectful submission is that
that is, you said you want to argue on the merits of it about maintainability of a review.
Please,
I
ma'am.
also asked you to find out from your client what is the feasibility
please, my lord.
for the
But-
visitation.
Please, my lord. My respectful submission is that, my lord, when the order is modified, it would set a wrong precedent at the bar, my lord. He was represented by an advocate, my lord. Senior counsel has addressed the arguments at length, my lord. When this order is modified, when the party in person comes again and recalls the order, it will set a wrong precedent at the
That
bar,
the
my lord.
court will look into.
That is one respectful submission, my lord. And then he's making allegations against the advocates as well, my lord. Kindly peruse the IF for a minute, my lord.
That is not your concern. He is not making allegations against you.
No, and at the bar he's making allegations, my lord. When this goes on,
Mr. Counsel, don't go into all that. I have only asked you, if you want to argue that review is not maintainable, I can understand.
let him file an appeal or let him file a modification here before the family court, my lord. We can concede to that, my lord. Because when the judgment, once it is pronounced and then it is modified, it would set a wrong precedent at the bar, is my reference.
That is the lookout of the court, okay? You don't have to worry about it. You can only address the arguments
Please.
on the maintainability of the review and what are your instructions from the client
Please, ma'am.
with regard to that. That you please address. Yes,
I would pass on two judgments, my lord, of
Yes.
the Madhya Pradesh High Court when review is not maintainable.
yes.
My lord,
Yes.
I need to get a copy.
Yes,
Page number 9, my lord, para number 11.
yes.
In this, the Honorable Court has held catena of judgments, my lord.
Hmm.
In para number 9, my lord, I would read stating that an error that is not self-evident and the one that has to be detected by the process of reasoning cannot be described as an error apparent on the face of the record of the court to exercise the powers of review. The Honorable Apex Court has held as under.
These are
What-
all the judgments of the apex court.
Please, my lord, when the review is not maintainable, when the matter was heard at length, my lord. And then I would pass on another judgment of the Supreme Court on the same issue, my lord.
Yes. Relevant paragraph
Paragraph number 20, my lord.
20.
22. It starts from 20, my lord. Time and again, this court has raised
Hmm.
my lordship lands, my lord.
Hmm.
Against frivolous appeals and petitions by imposition of costs on the litigating parties, this court in the case of so-and-so held the following. It was held in detail, my lord,
Yes,
when it is not maintainable.
yes.
Now coming to the IM, my lord. He's asking for enhanced visitation rights, my lord. Admittedly, we are providing visitation on every weekend, my lord. Every Saturday and Sunday, he's exercising his visitation rights and video calls as well, my lord.
Yes. Hmm. Yes.
And he's making allegations against the wife as well, my lord. In GNWC cases, my respective submission is that, my lord, there are two things. One is fighting for the child and fighting through the child, my lord. When he is fighting for the child, then that's a different issue, my lord. Now he is fighting through the child, my lord. Whenever he takes the child during physical visitation, my lord, he is taking child to the Kabban Park and malls, my lord. And child is not keeping well and is blaming respondent, my lord, that she is not taking care of the child, my lord. I would pass on some conversations as well, my lord.
What are they?
Wherein, my lord,
What are they?
WhatsApp chats, my lord. He has taken the child to the Kabban Park. The child was drenched in the rain, my lord. And the child was not feeling well, my lord. And he didn't even go to the school and is blaming the respondent, my lord.
Hmm.
Respondent, that is petitioner here in wife, that she is not taking care of the child, my lord. And he goes to the doctor and make a findings that he
That's
has
already
to.
over. That's already observed. That's already argued in the main petition.
Please, my lord.
That I've already given a finding on.
No, admittedly, the petitioner is also highly qualified, my lord. Due to the child being 3 years of age, she is unable to go for employment, my lord. Now she is out of the cruelty meted out to her. She is residing at her brother's residence, my lord. Presently, she is at brother's residence. During weekend, every weekend, he is getting visitation, my lord. Even she is unable to go to the take the child to some other places during vacation as well, my lord. And video calls is blaming the petitioner that he is unable to cooperate with the video calls as well, my lord. Even though she is trying hard to facilitate the video calls to the respondent, he is making all the allegations against him, my lord. He is not commencing his evidence in the family court, my lord. Matter is of the year 2023. Till now, he has not commenced his evidence and is filing applications against applications, my lord. Till today, he has filed 13 applications, my lord.
19.
Yes.
My lordship, I thank the opposite counsel for bringing up that I'm fighting through the child. My lordship, in fact, this is exactly why I wanted to submit this affidavit, my lordship, because something I cannot say in the open court. If you go through point 2 and point 3,
Everything,
my
whatever
lordship,
you want to say, all the documents the court will not see.
I want to reunite with my wife, my lordship, and she is here in the court. It is not true that I'm fighting through the child. It is we want the best thing for the child only, my lordship. And most of the things are allegations which do not fall under the purview of what grounds under which the petition was writ petition was filed. I would request to constrain to this limited aspect of visitation, my lordship.
With the any matrimonial cases are pending?
No, my lord. As of today, only
GNWC is
please.
pending. Then what about is the wife interested to join the?
No, my lord. Out of the cruelty meted out, she is supposed to file divorce petition, my lord. She is yet to file.
There is no matrimonial case.
No, as on today, it is not filed, my lord. As on today, it is not filed. We in fact suggested couple counseling as well, my lord, in the mediation, and we have suggested 2 couple counseling, but things couldn't work out of that mediation.
My lordship, they keep coming up with allegations of cruelty, my lordship. I'm a lay person. I'm appearing as a party in person. These allegations are unfounded allegations, my lordship. I have to keep a job for my son and for my parents and my family. If that was true, they could have filed a case. It has been 2 years in separation. And everywhere they go and make such allegations, and not a single piece of document on record, my lordship.
Till now, he has sent 5 advocates at the family court as well, my lord. And he has consulted 15 pediatricians in Bangalore city, my lord. He is finding fault with each and every person which he consults, my lord. Till now, 15 pediatricians he has taken.
How the wife is keeping a complete watch on the number?
No, but he is consulting because 15 doctors, he is finding fault with one pediatrician and he is asking.
How many doctors is going, how many advocates he is meeting?
No, my lord, he is finding fault with each and every person is concerned.
Both the parties shall appear before the chambers at 5 o'clock.
in chamber at 5 p.m.
Please.
I'm sorry.
Cell number 5 in chamber, sir, at 5 p.m.
5 p.m. Okay.
Cell number 5.
Yes. 5 p.m. on Tuesday, not today.
Oh, okay, my lord.
Yes.
Yes. I have moved the matter. The service is complaint. The
Cell number 5.
cause list shows that the hand summons is not served. Here they have entered appearance. And therefore,
My lord,
Yes.
I formally objection I am filing for this reason, my lord. There is a total amount due is about 38 lakh, about 48 lakhs, out of which 30 lakh 15,000 is still due. I'm bringing it to the notice of this honorable court by filing these objections. Court of.
No,
Yes, ma'am.
we are on the point.
lookout
It is a
circular.
lookout notice, lookout notice.
Whether please show any law on that the family court for realization of the amounts, whether it can issue a lookout circular. That's the only issue, not about the other issues. That day, that's what I told him, because legally it's not correct. And that's why he,
2 lakhs have been deposited.
No, this honorable court, my lord, there is a conditional order while passing
was he
this.
completed,
Yes, yes.
that order is complied with?
Yes, I have
He
deposited.
has complied with it. I may be permitted to withdraw that amount, my lord. That is in the court.
This petition ultimately has to be allowed.
My lord, if that issue, which becomes academic, I think, according to him, if it is to be addressed, I will place the citations on
Please do place.
or Tuesday, my lord.
But my
This is
my
matter.
only one endeavor. But I filed an application.
There is an application.
But I have told even to the informed the court officer that the IA is not put up. Informed.
There is the.
Anyway, I have the office copy. Shall I pass it?
Yes, I have. He has served the copy.
Only difficulty is this. Otherwise, I would not have moved. ಬಂದಿದ್ಯಾ ಇದೆಯಾ ಇದೆಯಾ ಪ್ಲೀಸ್ ಬಟ್
Court officer.
But the difficulty
Objections,
is,
sir.
no, the court keeps on clarifying the doubts of the police. Is it the duty of the court?
no what
Or if
they
they
have
are not
did
able to understand what the court
but
said,
what
they will be doing it-
ultimately I am the sufferer mullet where you lost me kindly have a
they would be doing it at their risk.
page 10 of my document. He has been offloaded from the flight. Though there is an interim order is operating, but I am working from since 34 years. If I lose the job, even I written a mail that I need 10 days time, ink page number, document number 4, page 11. Thereafter, after I have been deported from the airport, and even my the temporary visa, I remain only in another 4 years in the job. Page 5.
No.
That expires on.
No, who is the, who has, somebody have requested for this? Which police
Fourth
station?
respondent, the party on which the trial court has ordered, I have made him a party. The Commissioner of Police, ink page number 4 of my writ petition. I have said so in my application that the Mulki police, under the whose jurisdiction the petitioner is residing, they, the airport authorities, once the lookout circular is issued, your lordships are aware, that will
be
point
a-
out.
First of all, whoever is in charge of a particular police station, he will be the authority who will be making a request to the higher authorities.
Correct.
The higher authorities in turn will address.
Every
a letter
efforts
to
have
the-
been made.
One minute. They will make a letter, they will address a letter to the immigration authorities, or that's how the lookout circular is issued.
Correct.
Once there is an order by the court, whose duty is that? Which police station is that?
Mulki police station. I have said so in my application, categorically stating
Have
that.
you, was this order communicated to them?
Yes, everything has been communicated.
You communicate,
But I
how
have
did you
given,
communicate?
even at the airport, I have given the order. Even the airport.
Airport authorities are nothing. You don't have
No.
to give them.
While I am coming, I have given the order copy.
How are they concerned? They are
But the
only.
police station, I am referring to the police station of the Mulki police. While I came on 28/7/2025, I came on 24/8/2025.
Who is the
Para
commissioner? 4.
Commissioner of DK district, Mangalore. He is the
Commissioner
superior.
Bangalore.
Mangalore, DK district. In their presence, the order is passed. Everything I did. Because ultimately, my entire thing, 34 years, my PF, everything will go.
Let the government advocate come. Call for the government advocate.
Please.
Cell number 6. Girish B. Baldare.
The maintenance awarded by the family
For
court
the respondent.
in the petition filed by the
What is this non-filing of wakalat?
Your Honor, I've received the wakalat last night. I'll be filing it today or tomorrow.
sovereign
We'll have
maintained
it some other day. Let him file wakalat. Land count for the respondent.
Tuesday.
Subject that he'll file wakalat today. This is the matter. Date Tuesday, Wednesday, when the.
That is 25/9.
Yes, next.
Much obliged.
Cell number 7. Hemalata V.
Kindly pass.
Huh?
Kindly pass over, my lord.
Pass over. Yes, next.
Cell number 8.
Pay for the petitioner.
Cell number
Petition
8.
by the petition mother. My lords, what has happened in this matter is,
First office objections.
well, it's common order on both the applications. It's a common order, therefore, my lords,
Common orders are like, whatever it is, now
Please.
we have passed, already issued directions.
Please.
Because it is becoming difficult
Please.
to deal with it first. There are like, for example, IA number 7, IA number 8, you file one writ petition. Against IA number 7, this court will allow the writ petition. Against IA number 8, this court will dismiss the writ petition.
that's the confusion.
There would be a lot of confusion.
My lords, I'll not press on IA number 4 in this.
That you have to file.
My lords,
File a
the urgency is this, my lords. My lords, the urgency is this.
We will pass over, file it.
Please.
You're not pressing the other.
I'll file a memo. I'll file a memo that I'll not press on IA number. My lords, 2:30 minutes.
Yes.
Cell number 8. 230. Cell number 9. Hearing on interlocutory applications. Cell number 9.
Your Lordship. Your Lordship, on 22nd 7, there was a conditional order with respect to complaints of office objection, my lord. Subsequently, office objections was complied, whereas thereafter, a few more office objections were raised on that. So, when the file was sought for further verifying office objections, my lord, as there was a conditional order, it was informed.
That's a whole difficulty. In every case,
I
why
know.
should the court recall the
I
order?
apologize for that, my lord, because already it was complied, but few things that has been missed out. As it was a conditional order, it was dismissed for non-compliance.
It would be dismissed. No, it has become a routine practice. Every case, once the order, default order, then again come up with recall petition.
I understand.
No,
Your
unnecessarily, no, it has become, and on every recall petition, we'll impose costs and do it. On 22/7/2025, a week's time is granted to comply with the office objections. It is submitted that as the same as it's a default order. The petition is dismissed once the present IA is filed to recall the order dated 22/7/2025. The order date, for the reasons stated, the order dated 22/7/2025 is recalled on the condition that the petitioner shall pay an amount of ₹1,000 to the High Court's Advocates Association.
I make a submission, ma'am. Serial number 6, interim order may be extended, ma'am.
Interim order 6. Yes, next.
Cell number 10. Cell number 10. Nayana Tara.
Petitioner, my lords.
My
On the
lords, I
last
appear
day,
for the
the lordships
respondent.
had directed us to put a proposal forth between the respondent. We have done so on the 2nd of this month, my lords, after which they have rejected it, but they have not proposed a counter amount that they would be open to. Before your lordship, on the last occasion, this is regarding a property that's commonly owned between the two parties, my lords, between the husband and wife. So on the last occasion, we had proposed that we could buy out the respondent's share in the property, and that we would also detail the steps required to make that transfer of ownership and to ensure that no more liability rests with them. We have inquired with our banks, and we have found out that the particular process, we have put that forth, as well as our earlier offer, which was stated before your lordships, which is an amount that the respondent has already contributed towards, be it towards down payments or EMIs that have been paid for. And this is an admitted amount in a legal notice issued by the respondent to us. Admittedly, after that, there have been no further EMI payments made. So we put forth an offer of 32 lakhs, my lords. Prepared to pay that and take over the share as per the bank's required process.
My lords, I had filed my counter to their proposal. If I may just place it on record, I've already served them a copy.
And when did you serve?
On the
We've
15th,
received
my
it,
lords.
my
I
lords.
was directed to file it by the 15th. I have. If I may just place it for the
We've
floor.
received it and we've responded to the same as well, my
Why
lords.
this court is doing this exercise again and again? Call the order.
My lords, if I may just give some context, the application that we're before this court for is.
I remember everything.
Yes, my lords. So I have
what is
asked
this
for an
all going
extension
on?
of time.
Either both of you compromise on that aspect,
My
or
lords, I
else
understand.
I'll confirm, I'll dismiss your application and will confirm the order.
My lords, there is one aspect in my counter, if I may just point it out, my lords, and I've served them a copy as well. They wrote to me saying that their proposal is to buy me out at 32 lakhs, which is an amount they take from a legal notice issued by me previously. My lords, this amount is not correct. I can place the correct amount on record. It is much higher. That is a matter of fact which can be decided between the parties. If my lords could just have a look at my
Lords,
counter.
they could have
If I
proposed
may
that
just finish
amount,
1
whatever
second.
that amount
My
that
lords,
they
if
are
I may
claiming
just
is their
finish. If I
contribution,
may just
they've
finish.
not put that forth even till date, my
If I
lords.
may just
They're
finish,
claiming
neither have
vaguely.
they. My lords, in their proposal, they were supposed to in fact come forward and say what the contributions were.
How can
It's
we
a
say what
loan
their
account.
contributions are, my
My
lords?
lords, I will
I'll
pla-
prove my
if I may-
contributions.
My lords, if I may continue, I don't want to be interrupted like this constantly, my lords. I just want to point out one aspect in my counter, my lords. I have put forth before this court an affidavit by a willing third-party purchaser who is put on affidavit before this court at 2.6 crores.
Without going into all those aspects. Why don't you say that?
My lords, that exact amount has to be reconciled, my lords, because a lot of the payments that
That's
I
the
have
only
made.
issue. That's the only issue.
Yes, my lords.
That.
A lot of the payments that I
Please
have
do
made
that,
have
whatever
gone
it
through
is.
her, my lords. I have given.
Then talk to them.
Yes, they must also come forward for that. My
Then
lords.
we are
nowhere
not
saying,
coming.
in
It's
fact-
fine. I will dismiss this.
My lords, no, my lords. In fact, if you might just look at my counter.
If you do not have the interest to negotiate and talk, court have so many other things to take care of.
My lords, I completely understand, and we
Please do
appreciate
it.
the fact that the
I'm
court
not
is now
interested to go
listening.
into any of these issues. Please talk
My
to
lords.
both of you. Have a discussion.
My lords, it may be.
The parties are not agreeing on the if whatever is the amount that the husband is ready to forego his rights in respect of the property, that shall be placed on record, or else the IA that is filed before this court will be dismissed. Next.
My lords,
Much obliged,
if I
my
may
lords.
request for the 20th,
Tell them
my lords,
about-
I'll have the amount by that time. That's this
Yes.
Saturday.
Yes.
My lords, if they may also be directed in good faith to
I will
place
not
on
direct
record.
anything. Please do.
It is only for them to also come
Please, my lord.
forward
Not
and
the
say
duty of
what
the
their
court to do all that.
contribution is, my lords.
We
because
will
it
not
has
do
to
it.
be-
Will not do it. Please settle your dispute.
My lords, the accounts have to be reconciled. That is the only issue.
Whatever you both
It's
of you
your
want to do,
contributions,
we
the
will not.
respondents.
Court will not interfere. Yes.
Much obliged.
Cell
Yes,
number
next.
11 adjourned. Cell number 12. Sharat Gowda. 12 Sharat Gowda for petitioner. Vishal.
My lord, I'm appearing for the respondent in the second matter. I mean, in the first matter and the petitioner for first matter, my lord. Second matter, it may be passed over, my lord. Senior counsel is appearing in the matter.
She's asking for a Passover. What do you say? This is smarter after vacation. Yes, right.
Cell number 13. Cell number 13 Sachin BS for petitioner Ashok Kumar Shetty K.
My lords, I appear for the petition.
Yes. Huh? It is his petition. Let him argue. Argue the matter.
Please, my lords. My lords, 125 plus
Paragraph number 19.
Please, my lords. As observed, Supra, please, my lords. So, Supra, the respondent did not show any income in his affidavit, and it is observed that the respondent is a able bodied person and not no ill health, and he is a position to earn and maintain the petitioner. Already, the learned JMFC Code Mangaluru has passed an interim order of 7,000 per month in the favor of the petitioner, which is not complied by the respondent. Please, my lords. As the judgment of Rajneesh versus Neha, the court is required to consider the similar orders of the maintenance passed in the other case in order to overcome the issues of overlapping jurisdiction and to avoid the conflicting orders. By taking into consideration of these things and corresponding needs of the petitioners in respect of the maintenance, I am of the opinion that if an amount of rupees 8,000 per month in favor of the petitioner is awarded, in addition to maintenance awarded in the criminal misdemeanors. My lords, I don't have any job only, my lords. Previously, my lords, I used to earn rupees of 15,000, my lords, because, my lords, I am a vegetable vendor. It is not at all disputed, my lords. Subsequent to, my lords, after filing up repeated complaints, my lords, I have been not working as a vendor also, my lords. I have been removed from that job also, my lords.
Who will remove you?
My lords, I was working under a vendor shop, my lords, as a boy, my lords, sales boy. Now, my lords, currently, I don't.
Income according to you. Switch on the mic. Switch on the mic. Use the mic.
The respondent is having 3 kids. One was yet to be born when that 7,000 was ordered, Milord.
2 kids.
During pregnancy, she was thrown out of the house. So she has 3 kids, Milord. Now, even nothing is paid now except 8,000. That is my information. I will just check into the amount he mentioned and then submit, Milord. Maybe posted day after tomorrow.
No. We are not concerned with the arrears. We are only concerned with whether the maintenance that is granted by the court is right or not. That's only we'll decide. No adjournment.
Maybe passed over, Milord. I'll check with the.
If he is not having any income, on what basis the court can grant
I filed my
8,000, 7,000?
Well, I have filed my assessment liabilities, my lords.
Yes,
He has not paid
pass over.
anything. None of it.
Please, my lords.
Number 14. Hanumesh HN for petitioner. Hanumesh.
No representation. This is not after vacation. Yes.
Cell number 15.
I appear for the petitioner in the second matter. My lord, may I just make one submission? There are 2 matters.
I feel for the
For
petitioner in the
15 and
first matter.
15.1. 15 is filed by the father challenging the visitation order. 15.1 is filed by me challenging the child maintenance order. I have filed one more petition also challenging the visitation. Can that be listed and taken up together next week, ma'am? So that all 3 matters be taken up together.
Give the number.
Yes, number is WP
Write on a
28779.
paper and give.
I'll give the memo. It can be taken next week, my lords, 25th.
Monday, my lord. Monday or Tuesday.
We'll see. It's not possible. It's only 1 week left.
Yes, any day. It can even be after vacation because ultimately for 1 year he is getting the visitation.
My lord, we're seeking custody during vacation.
No, not during vacation. They are not seeking.
My lord, we
during
have a
vacation.
prayer for 50% of the
Some
petition.
date. Yes, next week.
Next week, 15. Can it be 15?
15.
Convenient to the court.
Great.
My lord,
10. Cell number
And
16.
my lord, one of our prayer is 50% of the vacations. My lord,
No,
we
no,
have
it is
already
not
been
there.
granted summer vacation visitation.
It is not there.
For
I'm
Dasara
sorry.
vacation.
Bring the matter in the next.
Direction for the trial court for the expeditious trial, Your Honor.
Which year is the MC?
Annexure A, my
MC is of the year 2024. Which court is this?
third additional family court bank.
Your direction to dispose of your matter.
My lord, it's an ex parte trial, my lord. Ex parte trial. The respondent has not come on record in the trial court, my lord. Since then, they are filing multiple cases. Once we have filed this case, then
We will not grant any direction to dispose of a matter of 24 when old matters are pending. there are no reasons for the court to take a view, to direct the family court to dispose of this matter
My
out
lord,
of term.
my one concern, my lord, I'll just bring it to the notice of this court, Your Honor. Kindly see the writ petition filed by them at Annexure E, my lords. They have filed one writ petition seeking for withdrawal of this MC case. One MC case is pending in Ukkeri. Uh, During that, my lords, they have taken the stay. On that day, it was granted for 15/11 for November. Now we are advancing the case in the trial court, but they are not ready to take the further chief in the.
Will not take care. 24 matters, they will not conduct the trial now. They will only complete the old matters. So this court cannot grant any direction to the family court. They're going in a procedure which is required for the disposal. Please come. The present petition is filed seeking the following prayer. It is submitted that in view of as the respondent is set ex parte, and if the trial is completed, it would the it is submitted that the respondent is filing multiple cases, and there shall be a direction to the family court to dispose of the matter expeditiously. Same like in other matters, this court has granted direction, and so this court finds no reason. Accordingly dismissed. Next.
Cell number 17 adjourned. Cell number 18.
For petitioner, my lords.
Yes.
My lords, in the previous date of hearing, your lordship had in fact directed the respondent to submit documents to show that he is making payments to the petitioner under various heads, my lords, for which he has filed a memo. But he claims that every month he is transferring 25,000 rupees to the third petitioner to Bank of Baroda account, my lord, which is not correct. The rest of the money which he claims he's transferring, that is school fee, van fee, etc., and all, my lords, it comes to per month 31,000 rupees, my lords. His salary per month is around 2 lakhs. He's paying school fees and tuition fees and other miscellaneous expenses for the children. Roughly, it is coming to 31,000 per month. In addition to that, he also claims that he's transferring 25,000 rupees per month to Bank of Baroda for third petitioner, which is not correct. If at all he transfers that amount, I have no problem, my lord. I can withdraw the petition, my lords, because my only seeking the relief is the enhancement needs to be made.
May I please? Prior to that passing of the order, after passing of the order, I think he has not transferred 25,000. Earlier, he used to transfer 25,000. That I will inquire him and confirm whether.
That's the only issue. Please find out. We'll pass orders today. Sir. There is nothing to keep this matter pending.
No, he is in Dubai. He is in.
Cell number
He's not
19.
in-
Why did he make a statement?
No, this statement.
Bank of Baroda, no, Bank of Baroda, you said she is transferring.
No, I'm not. I'm sorry. In the statement, I clearly mentioned what the exactly amount has been transferred. In the memo, I am not said 25,000 is transfer every month. I'm sorry. I am not made such a document.
You that? What is the document filed by him?
My lords, even if that memo is taken into consideration, it's very clear that he is not paying the money regularly, my lords.
No, let him clarify where I said that 25,000 is been
You're
paid.
saying that according to him, he is transferring the amount to Bank of Baroda account. Where do you get that? Mr. Mohan.
My lords, your lordship had observed based on his statement to the court in the previous date of hearing that 25,000 he is transferring to Bank of Baroda, my lords. That is what he had claimed, my lords. Your lordship tended to see the order dated 23/7/25, my lords. 23/7/25, he submitted before your lordships on record that he's, apart from other things, he's transferring 25,000 per month.
Please, I take your lordship to page number 30 of the.
Read order dated.
No, I will clarify that. This order came to be passed on the statement of objection by me before the trial court, family court. Your lordship observed in the statement of objection, 25,000 was paid In this statement, I have not stated.
What statement? In your presence?
In your, sorry, I am sorry. In my presence only, the order is passed. I take your lordship to page number 30 of the petition. That is the statement I filed before the family court. Based on this, I made a statement. Your lordship may kindly see page number 30.
So this statement, there was a statement before.
Earlier, prior to that passing of the order, 25,000 was transferred. Subsequently,
The order is passed in the court in your presence. When you're understanding what the court is saying, if according to you, it is not correct or you have not stated, is it not your duty to tell the court? Now, when after an order is passed, it is not open to any of the advocates to say that I didn't say that on.
No, I am not saying. I am not saying. I
specific instructions from your client. List this matter as part heard on Monday.
Grateful, my lord.
Learn counsel for the respondent shall get specific instruction.
Cell number 19.
For the respondent in this case. Your ladyship,
Look,
this
this
case
is a-
was listed on the.
This is a matter which was
Eight-
She was
already
not
heard.
present. I have adjourned the
I'm
matter.
extremely
was
sorry.
adjourned and the,
She came and made a mention.
your ladyship,
So that's how it is listed.
your ladyship, now I am in the midst of a research where I have to produce certain documents.
That day, if I heard the matter, what would have happened?
I have certain documents. There are certain more documents.
That day, if she was present, if I heard the matter,
In
what
fact,
would have happened to
no,
the research?
even on that day, I was in the midst of the research. I have certain documents which state that how a particular matter when there is a person involved who's a pedophile, what has to be done, what is the psychology, what all those things are.
No, all these research should have been done when you filed an application before the trial court, not before this.
No, it is not my application. My application was at the time of filing the petition saying that the mother should be restricted from taking the child. Now, in fact, they have filed an affidavit which states that when somebody states that a particular person is not residing, who has allegation against them of having committed aggravated sexual assault against a minor daughter, when they say that there is an intention to show that this child will have no contact with the child. In fact, I have documents showing that on a subsequent date.
I fail to understand what that has got to do with this.
Because
petition at all.
one document which he
Come to
produced.
both of you restrict your arguments to the impugned order.
Yes,
Please, my lords.
impugned order.
Please.
The other things. Please come to the impugned order. Where
May
is the
I
impugned order?
show one document, an affidavit that she has filed, which shows that.
Let's see the impugned order.
Yes.
What is the connection with that impugned?
Page
number?
136 it starts. However, the operate portion, my lords, is at page 145. Plus ink page 145, my lords.
What is the order?
Let's order. May I?
Yes.
Now, should I read the
operative portion?
Operative portion. IA8 filed by the petitioner under section 12 of GNWC read with order 39 rule 1 and 2 and section 151 is hereby allowed. The respondent is hereby directed not to take the children from out of the jurisdiction of this court till disposal of the petition. This is the order.
Where are you reading? 140?
145.
Last, my lords, 146.
146.
That is the last annexure.
No, please, the petition is granted visitation rights to meet his children by name so and so between 3 p.m. to 5 p.m. The petition is directed to take care of the needs of the children and also directed.
Plus that is
not to
IA5. Your lordship is.
I'm looking at IA5.
This is IA8, my lords.
Where is
IA8.
that?
Plus
IA
IA same. It's a common order, my lords.
IA number 8 filed by the petitioner under section is hereby allowed. The respondent is hereby directed not to take the children out of the jurisdiction of the court till disposal of the petition.
Petition.
Yes.
Plus the reasoning given, my lords, just one page earlier, that is page 145. The second line it starts. The respondent is also educated person and she may take up job anywhere and there is a apprehension of the petitioner for shifting the child. That is all. Therefore, considering the facts of the case, issuance of direction to the respondent is necessary not to take the children out of the jurisdiction of the court till disposal of the petition. This is all the reasoning that the court gives. The court tells the mother is taking care of the children well, just in the same para earlier. Everything is observed.
And let's see the IA number 8.
IA number 8 minutes.
Page
Is
number?
that page? Plus IA 120 minutes. 120, ink page 120.
The relief sought by the petitioner, my lords. Your lordships got it?
Yes.
At page 120, annexure F, my lords. For reasons sworn to in the accompanying affidavit, the petitioner humbly prays that this honorable court may be pleased to grant ad interim ex parte order restraining the respondent from taking the minor children, namely Kavin Chandrasekhar, age so and so, daughter Anya Chandrasekhar, age so and so, out of the jurisdiction of this honorable court, pending disposal of this petition in the interest of justice and equity. This is all the relief that he seeks.
Paragraph number
there
9 of my affidavit.
Where the brother stays?
Milas?
Yeah, that is, I will tell. She has given an affidavit to that effect. No, she has given an affidavit. That affidavit is false.
Please wait. I just said, don't have to, both of you just understand what the court is asking.
Yes.
Nothing to excite here. No, I said where the brother is staying.
With in the same house.
No, my lords.
In the same.
I'm sorry.
So he is staying in the same house.
Yes.
What is the order of the court? Not to take the children out of the jurisdiction of the court. No, she is only on that point. You are on the point that the brother is staying in the same house.
Yes.
That is not dealt with by the court, nor you are aggrieved
No,
by the...
I am aggrieved. I have filed an application to that effect, saying that in the lower court,
that the court will take
initially
care.
I had come to this court, 2819, I had filed before this court saying that the children are not safe because they have, he's holding the children on a subsequent date when an affidavit is given in the month of September of 2023.
Counsel, please wait. I can understand you are dealing with the case and you have so many issues. All the issues will
My
not
issue is only
will
safety
not
of
be
the
dealt
children.
with by the High Court. Please understand what is the scope of this writ petition. Are we enlarging the scope of it or not? Now, whether what he is doing, what is your problem, what is their problem, will be dealt with by the court in an appropriate application, which is pending consideration before the court. As far as this IA is concerned, what you sought is, there is an apprehension that she will take away the children from the jurisdiction of the court, or she will go away. She's having the Aadhaar card, she's having the passport and everything. That's your
In
apprehension.
addition to that.
Now, brother staying in Bangalore in the same house, that will be taken care of by the court. Now, what is the clarification she is requiring? If she has to take the children even to a place like a nearby place also, this order is coming in her way. What is the connection between that and the brother staying in the house? Will that be decided by the court in this application?
My apprehension is the moment they move out of the jurisdiction, there will be uncontrolled access to the brother. Because this has happened on an earlier occasion where she has filed an affidavit.
What is not happening in the house will happen once they leave the place.
We don't know what is the condition.
What you
of the
don't know,
children.
here also you don't know, there also you don't know. So, because you filed a GNWC and you will not have absolute control about where she sits and where she
No,
sits.
I'm not saying, I'm not trying to control her.
Yes.
She can go, but in the meantime, let the children be given.
Yes.
If she is going, let her go. Let the children be at a place where which
This
is
is
safe.
not the way the matters are fought between the parties. This is
No,
not the way.
in fact,
carried.
In fact, your ladyship, my submission is the conduct, how she has been making false statements, and what would be the need of filing this affidavit, giving false statement, and subsequently next year he's holding both the children, and this person is accused of molesting his own daughter. And in fact, the behavior of a particular person.
I will leave it open to you to agitate all these issues in the pending application before the family court. This has nothing to do with that. I will leave it open. I'll record your contentions. I'll leave it open to agitate before the court for modification of this order, because the court or anybody cannot curtail a person from doing a particular days.
Yes.
So what the mother has to do with her life is not at all your concern, along with the children also, because they are not with you. I
am okay. She wants to spend time with the children. She is with the children. My only concern is the safety of the children, and in fact, my apprehension
Are
is.
you monitoring the safety of the children in the house? You're not monitoring.
In fact, they have given an affidavit saying that he is not residing there, but I have documents to show that he has been accessed.
That you will deal with it in an appropriate
Yes, and
application.
in addition to that, I have filed.
This application, that brother's issue cannot be a part of this issue.
In addition to that, I
Yes.
have filed applications for this Dasera for everything, and
Be dealt with.
and that
Will be dealt with. If once the court passes an order, then that particular day she has to stay back, is it not?
That goes
So,
without saying.
in fact, earlier she had 110 order of this in this court. 110 order may be looked at, your ladyship. She has stated that she will, on a condition, she was allowed to go to Goa, saying that I will come back and give the, if 110 order may be looked at. She has violated that as well.
I will also pass an order. I will now, and this I'll clarify. Whenever the order of the, I mean, wherever the visitation is granted, she has to strictly comply. And also, if any of the applications that are pending, subject to the orders that are passed.
And may I request, if there is any need, urgency that
Why should it be?
not
Is
every
she a
day.
criminal?
It is not an every.
That she should file an application to leave Bangalore for every time.
No, because my only.
Please don't. It's not the way. It's not the way you deal with your life and the other's life also.
No, whenever she's taking the children, at least when she is going, she may take.
Children or her children also. Is it not?
Indeed.
The present writ petition is filed.
My document may be taken on record.
Why?
And one report I am filing.
I will not take any of it. I will both the parties settle the disputes, and why are you people making the life, your life as well as the life of the children?
He doesn't want to come before the court for settling.
I have given my proposal. I am saying I am giving you a house. You come reside there. My only apprehension.
It is not. You cannot call it a compromise. You cannot. You are dictating terms.
No, I am saying my only, your ladyship.
You say you come and stay in the first floor of my house, and I'll be under my nose. You do everything. Is it a compromise?
I am saying I am paying for the education. I am paying monthly maintenance also.
The present writ petition is filed, questioning the order passed in I number 8 in GNWC number 137 of 2023, dated 5/1/2024, whereby the court had allowed the IA that's filed under Order 39, Rule 1 and 2 and Section 156 CPC, and directed the mother not to take the children out of the jurisdiction of the court till disposal of the petition. The agreed by this, the mother is before this court. Then counsel appearing for the mother submits that the court, by way of IA number 5, the court had granted visitation on every Thursday between 3 p.m. to 5 p.m.
It was subsequently changed already.
What is it now?
It is 10 a.m. on every Saturday. For the elder one, 10 a.m. to 10 next day 10 a.m.
Which is passed by this court.
By this court.
By this court. In
For the elder one,
2819, my lord.
and for the younger one, it was 10 to 2.
10 to 2. It is
On
submitted
Sunday.
On Saturday.
Saturday.
It is submitted that the court this court had granted the visitation to the elder one from 10 a.m. to 10 a.m. Saturday to 10 a.m. Sunday. And for the younger one, it is 10 a.m. on Saturday to 2 p.m. on outside Bangalore. She is not in a position to travel. And in fact, when she traveled to which place you are submitting?
Milord's Nandi Hills. She just
Devanhalli.
took, because he was aware it was for a birthday party.
Nandi Hills, which is how long it is?
Milord's, it's hardly about 60 kilometers, I would say.
When
72
taking the children
kilometers.
from to Nandi Hills, which is 70 kilometers away from Bangalore, the father has moved a contempt petition.
I have not moved contempt petition. I have
Contempt
filed,
notice, my
I
lord.
have sent an
Contempt
email.
notice.
Have issued a contempt notice that I think all either
No, on the day when I was supposed to have visitation,
that.
she goes there.
He exercised his visitation rights. She just took him to the birthday party of a common friend.
not able to understand whether the emotions of the clients are coming to the advocates or advocates' emotions are percolated to the clients. How it is happening? What did you write? Contempt notice to the mother. It is submitted that mother has no intention to take the children out out of, out of the, has no intention to take the children out of the jurisdiction or to deprive the father from visitation. But being and she as a human being also has has uh, uh, has a right to move around within the country, and by order impugned, the court had deprived the petitioner.
Let's, sorry, Melody. Within the country, outside the country, I think she should not be, as long as visitation order is
Not
complied, I
outside
don't
the
think she
country,
should not.
not outside the country, within the country, and she cannot be deprived of her fundamental rights just because a matter is pending before the court. Next part. Plenary counsel appearing for the respondent father submits that there are, as I alleged, act against his own daughter, It is submitted that brother is staying in the very same house, and it is not in the interest of the child, and the children are not safe with the husband, with the children are not safe in that house. They have given earlier they have given a affidavit that he's not staying in the house, and he has the photographs to show that that he is holding the children. It is submitted that the children are not, they are not secured in that house, and now if she is permitted to leave, the acquaintance of there would be a more scope and interaction with the brother, which is not in the interest of the children. It is submitted that the court, considering all these aspects,
I have
rightly
two,
directed.
3 more contentions that my other IAs are pending. My other IAs are pending.
I'll tell you.
And my another contention that
Please wait. If I don't, then you can add. What did you write? Has rightly been considered by the court, and had court had rightly not granted, directed the petitioner mother from leaving the country. It is submitted that, bringing all these facts about the brother staying in the house and having close access to the children, he has already filed an IA. That IA is pending consideration before the court. It is submitted that at this point of time, if any modification of the order, modification to the order would not be in the interest of the children, in the interest of the children. He would be deprived of his right to meet the right to have the access to the children. It is submitted that there are no interference is called for, and the petition needs to be dismissed. Next part.
one another things, they have businesses all across India, so they may relocate. They have businesses all across India.
It is submitted that the petitioner, the mother's family is having business throughout India, and there is every scope that they may relocate. Next part. Having heard the counsels on either side, peruse the material on record. This court has perused the order on IA number 2. The court observes that the wife is also an educated person. She may take up job anywhere, and there is apprehension of the father, apprehension to the father that she may ship the child. Therefore, this order is passed. This GNWC is filed in the year 2023. What is the state of the GNWC?
Orders on IA.
Orders on IA, Milord.
The GNWC is still pending on orders on IAs. The trial is not yet commenced. When the GNWC will be disposed of, it is not known. When an application is filed seeking injunction restraining the party from leaving the jurisdiction of the court in a mechanical manner, court should not pass any orders. If the cases are taking years together, and if there is an order that a party should not leave the country, that it would not leave the jurisdiction of the court, it would not be a justified order where a person's right to life and right to movement is curtailed, freedom of movement is completely curtailed. When these kind of orders are passed, they don't have.
They don't. Second child does not have, first child, it's already expired.
Expired.
Yes.
The court can pass an order that the passports be deposited before the court. But in this case, the first son's passport is expired immediately, and second son, both
Daughter,
Child,
daughter.
daughter does
second
not have
daughter-
passport.
Second daughter has no passport. In that case, question of taking the children outside the country will not arise. Then coming to the aspect of going around, the court, if they are, if she takes any, she makes any efforts to settle somewhere contrary to the orders of the court is not helpless. Court can always take appropriate steps to ensure that they are brought within the jurisdiction of the court. So in the considered opinion of the court cannot impose such a restriction as long as the orders of the court are complied with. That order should always be a last resort when the party is behavior is party is not complying with the orders and are complying with the order. Then coming to the visitation is on a Saturday. So the remaining days, they are in the care and custody of the mother. The contention that the brother is staying at home, for that, whether it is true, it is correct or not correct, or whether it is in the interest of the children or not, that will be decided by the court in the pending application before the court. Then, if they want to go outside Bangalore on the other days for any of the reasons, that father cannot have any say in that. And for that, the jurisdiction of the Bangalore, it has no, it will not have any impact as submitted by the Senate Council for the respondent in these respondent. Now, it is submitted that some applications are filed seeking visitation on vacation. If those applications are heard and decided by the court, and if visitation is granted, the mother is bound by those orders, and naturally she cannot leave the jurisdiction of the court during those times of visitation that is granted to the father. In that view of the matter, this order dated so and so is set aside. Is set aside. Accordingly, writ petition is allowed.
May I request that the observation with respect to the pending IEA for injunction against the brother, the observations here may not be.
Any of the observations, the observation that are made by this court are only for the limited purpose of disposing of this application, and it would not come in the way of the respondent with regard to the pending IEA, and court shall decide the pending IEA with regard to the brother of the petitioner in accordance with law.
Expeditions.
Great.
Number 20, urgent. 21, Suresh Babu BN.
Respondent, my lord.
Respondent has
My lord.
submitted the copy on 16th only, my lord. Kindly, we need to go through the application and to file objections and the voluminous documents they have furnished.
What, nothing to be produced. What is, no, what is the order?
My lord.
Let's see.
Order, this sound code on
My lord,
Not
there
that order, impugned order.
There are two.
order to produce the child on every Saturdays, but
Let's
11
see.
o'clock. And there was an interim arrangement by this sound code, my
No,
lord.
we'll dispose it off. Why are we keeping it pending?
No,
What is the order?
My lord,
On
already Monday I have
2016,
served, my
my
lord.
lord.
Let it,
I
those
already Monday
documents are the
served, my
new,
lord.
which are not filed before the family court?
No, my lord.
How can you file those documents?
My lord, because I have served the, these copies in Monday, my lord.
It has not.
Not Monday.
Please.
Why are you filing those documents
Well,
which are
because-
not before the family court?
They have obtained the interim order, my lord. That is the reason I have vacating this interim order. I have filed this before
Not,
this.
without looking at it, I'll pass orders.
Please, sir.
Looking at only the impugned order.
Kindly
Yes, pass over.
Number 22, Aishwarya R for petitioner. Judge Lazarus.
My lord, for the petitioner, my lords,
This
Where is the
honorable court, my
respondent?
lords, had directed assets and liabilities to be filed, my lords. Your permission, my lords, the assets.
File in the registry.
Yes.
This
please
is matter after vacation. No representation for the respondent. Yes.
Cell number 23, Pratima SK for petitioner, Abhijit SK, right?
This is regarding the maintenance that is awarded by the family court.
Any interim order in this?
Plus, no interim order has been passed because this is the maintenance order of
How much is
25,000.
granted?
Plus 25,000 is granted, though she is a double graduate. I have no issues paying for the child because she refuses to come and live with him.
What is your income?
Plus, writ is to set aside 25,000 that is granted to the mother.
How
That
much
is the wife.
granted to the son?
Right? 25,000 that is granted to the mother.
How
That
much
is the wife.
granted to the son?
Milords?
How much is granted to the son?
25, no, Milords, they say 25,000, the court says is granted to the wife. It should also, considering the educational expenses, however, the child is hardly 2 years old, Milords.
What is the income
They
of
have
the
not
husband?
been,
Income of the husband.
income of the husband, Milords, is around 1 lakh.
We'll see after vacation.
Milords, let there be, because the execution is filed, let an interim order be passed as to
25,000 which he is
plus
capable of
10,000,
paying,
whatever
we'll
he'll.
Yes.
Cell
24.
number 24,
Yes, generally I do not oppose. Generally I do not, especially when my learned friend,
You are not having the visitation from a very, very long time.
quite some time, Lord. They have taken a long time, my Lord.
No.
Yeah, the
no
father wants to
urgency
see the
time.
child.
From how many months he is not seeing or how many years?
2.5 years he has not seen.
So it
My
can
lord,
wait
my lord,
for another 1 month.
my lords, only because of your lordships, he can see the child, my lord. And I can also prove, in fact, in one of my client's case, where he was also fixed in a similar POXO case, your lordships was graceful enough to step in and ensure father will meet the child after 14 years.
We'll see.
This is that kind of a case, my lords.
We'll see
So
after-
unfortunately, my lord, this POXO is used as a very bad weapon
we'll see
for the marital dispute. So
after vacation, at the request of non-counsel.
at least may I request your lordship, since your lordship are pleased to hear it, I request your lordship to kindly make it as parted, my lord. Because your lordship have read the complaint.
Part heard.
Obliged, my lord.
It's 20%.
cell number 20, 25, Ravi Shankar TP,
But on the last occasion, I have filed an affidavit.
Raju Bhatt,
The order of this honorable court regarding visitation, my lord, is not complied with. I request your
I'm
lordship to
filing
kindly see.
affidavit of the facts which has been
Take this.
I request your lordship to kindly see my affidavit, page number, paragraph number 3, my lord.
Let him say, then we can hear you. What is this? What is this?
I have filed an affidavit of the petitioner regarding the interim arrangement made by this honorable court for visiting the child by the respondent as per the order dated 28/7/2025. In compliance of the order, the petitioner has took the children to the public place and she has visited the child, but she could not spare minimum time with the child and she messaged through a WhatsApp to take back the child.
What about the other order with regard to the daughter?
My lords, with respect to the other order
Where is the
passed by
complaint?
the Dr. M. Jagadish, he has declined to evaluate the child because he is oftenly visiting, traveling to other this thing. So that we have another doctor who will examine the child for evaluating the. So I'll recommend that who will examine the child for evaluating the. So I'll recommend that maybe. And even, my lords, my respectful submission before this honorable court, whatever the arrangement made by this honorable court may be extended for another 1 more month. Even I'm ready to, even in the previous 2 occasions, I have taken the child to the place. However, she did not turn up, saying one or the other reason. Now, this order may kindly be extended for 1 more month.
41 minutes. What do you say
Please.
about this WhatsApp chat?
Lord, I have filed an affidavit. I request your lordship to kindly see that. I brainwashed.
What does it mean?
Lord, the kid was brought to the park, fully trained, my lord. He was sent along with a mobile phone with the kid. The moment he dropped the kid with me, within 5 minutes, kids used to start crying, saying that I want my father. He used to call his father from his own mobile. The kid was having a small mobile with him. Within 5 minutes, my lord, he was waiting outside the park. He will rush into the spot, pick the child, saying that he is not comfortable with you. I'll take back the kid with me. Every time, my lord, all 5 weeks, the same incident happened. I narrated all that in my affidavit. I request your lordship to kindly have a look. And I have produced a photograph also. Your lordship may kindly
So
see.
what is to be done?
My lord,
What is to be done? Not the problem. Tell the solution also.
my lord, I have 2 submissions, my lord. One, my lord, let the interim management may go on. But 2 things should be made clear. The child must be with me for 3 hours, irrespective of any other aspect. And he should not be there in the spot. He is sending
The
the
court
kid.
asked him to be around.
No, but he's
Why
there.
is he being around?
He never leave the spot, my lord. He will be waiting outside the park.
Is it so?
No, my lords.
Kindly
Used
see the
very
photograph which
near-
I produced.
His house is very nearby, my lords. He used to go back to the home, or he used to go back to having some coffee in some hotel. In fact, in their affidavit itself, they themselves say that they cannot take care of even 20 minutes, my lords. Not even at 10, 20 minutes.
I can take care
They
of the
used
kid
to
even for
create a
20 days.
situation
my lord.
saying that I used to brainwash the child, I used to tutor the child before dropping.
Kindly
This
see
is
this
what
photo,
the,
my lord. Kindly see
this
this
is
photo.
this is what they are portraying from the day one, my
Kid
lords.
was, my lord, trained not even show his face. He was closing his face.
My lords, this
from
court
his
has
hand.
advised on the previous occasion so as to make comfortable with the child for some more time. That requires some more time, as this lordship has advised. But they are not spending any time with the
The mother will do to him.
nothing, my lord, if he wants to talk to
Why a child going to meet the mother should carry the phone and play with the phone?
only it was a basic phone which was given to him
Oh,
for.
whatever it is, why
Fine,
phone should be
I'll
given?
not give anymore. I'll not give them. Even in fact, your lordship may kindly peruse in page 12 what they have referred in the next line. Come and pick. I don't know where he is. And she also goes to threaten me, saying that you will face the consequences of before the court.
Obviously, if you are not obeying the court order, you have to
Alas.
face the consequences.
ಹೇಳಿದ್ದಾರೆ. And more so, my lords, she says that in her affidavit she resides at Shivamogga.
No, no,
And
no, no. That is my
please,
permanent address. Presently, I am residing in Bangalore.
That
I'm
has
not
not been
coming from
stated anywhere
Shivamogga.
in the affidavit, my lords. That has not been stated anywhere in the affidavit. And she used to say that I used to travel 2 hours. In fact, Shivamogga is 310 kilometers from Bangalore. If anybody wants to travel from private vehicle, minimum 5 hours is required. Minimum 5 hours is required.
I am
And
staying in.
even in the before the trial court also, they never whispered about their present residence at Bangalore.
It's not right. That day there was no reluctance from the boy when he met in the chamber. He was all right.
Is very shy and he is not ready to open his mouth in before anybody apart from
The
his
father
father.
be not around.
Apart from my lord.
Should the father be not around when the visitation is going on?
No, my lords. No.
Please come.
And my lord, I have one more request, my lord. Now, my lord, Dasara vacations are coming, at least for 2 days, my lord. I may be permitted to have the.
Paul, you're not able to manage that kid
Please.
for a few hours.
No, my lord.
Then you say that you will keep him for 2 days. How is it possible?
Lord, I am certainly able to manage the kid.
According
if he
to
is,
you, father has brainwashed him.
Yes,
He has brainwashed.
exactly.
So what will you do for 2 days?
No, at least.
This court on 28/7/2025 has passed an order whereby permitted the mother to exercise the visitation at Vijayanagara Park at a nearby place where the father is residing between 12 p.m. to 3 p.m. and also directed the father to take the daughter to the doctor, and basing on the doctor's advice, after completely evaluating the child, the doctor shall send a preliminary report to the registrar judicial on 25/9/2025. Both the parties have filed their affidavits. According to the mother, the boy is not spending time with her as he has been brainwashed by the father. According to the father, mother is not spending time. It is a complaint of the mother that the boy is coming with the phone and the father is around. The counsel appearing for the father denies the same and submits that when he is exercising the visitation, the father is leaving the boy at the park and is going to the house which is nearby. And the allegations are baseless. Considering all this, and it is submitted that the doctor, accordingly, this court is passing the orders. It is on Saturday. It was on Saturday or Sunday?
Sunday, my lord, Sunday.
Until further orders on every Sunday, as per the earlier order, that is between 12 and 3 p.m. Mother can exercise the visitation. Number 2, father shall not be within the vicinity. He shall drop the child and he shall leave the place. The boy shall not be given any phone. He shall not carry the phone. Third, the daughter shall be, the father shall take the child to so and so. And after evaluating the child, the doctor shall send a report to the registrar judicial. This is matter after vacation.
Great. Any date may be given.
They'll give the date. After vacation.
That is 13/10.
Yes.
Lord, maybe made clear that at least for 3 hours the boy will be with me.
No, if you are sending message and asking to take him away, what the court can do? That's what the WhatsApp says. Yes.
Finally, cell number 26, Deepa J.
My lords, I'm
Petitioner.
appearing for the petitioner, but I
HJ
want to
Muniswamy.
mention just one thing before this honorable court. The conduct of the respondent, my lords,
First of all, come to the impugned
My lords,
order. Let the court understand what it is.
No, my
Then
lords,
you
I'm
can
not,
tell the conduct.
I'm not on the main matter.
Understand what it is.
No, my
Then
lords,
you
I'm
can
not,
tell the conduct.
I'm not on the main matter. Yesterday, they have filed before the counter the objections with documents. They did not even have the courtesy to serve me before filing in the counter. Today, I'm here since morning. He serves me at 12:20. Technically, he's supposed to be serving me before filing it in the counter.
Lords, we made an attempt to contact yesterday. Phone number was not.
Court has no time for all this.
Please, my lord.
Please come to the impugned order.
My lords, your lords may kindly have the impugned order, which is at annexing his stand seeking 50% of interim custody of their son. My lords, I would want to state at the bottom, the respondent has filed objections is written. They have not filed objections to my application. The petitioner has not filed any objection and has not opposed my application also.
Read it, complete it.
The petitioner, the wife, has filed the main petition seeking appointing her as the guardian of their minor son. In this case, the respondent has filed IA number 8 seeking interim custody of their minor son, and this court, wide order dated 4/9/2024, allowed the respondent having interim custody or visitation rights of his minor son twice in a month on every Saturday and Sunday, and first Saturday and Sunday, and third Saturday and Sunday. The respondent, even on passing such order, has filed nearly 5 or 6 IAs seeking interim custody of their son on various occasions, saying the birthday of himself, birthday of their child, and also seeking custody during festivals or vacation. It is on record that the petitioner, aggrieved by the order passed by this court on IA number 8, questioned the same before the Honorable High Court. The Honorable High Court has made interim arrangement by reducing the overnight stay of the minor son with the father. Here in this IA, the respondent father has sought 50% of interim custody on the child who is aged about 3.5 years. In this backdrop of the facts, I am of the opinion that the respondent is not entitled to seeking 50% of interim maintenance of the child pendency of the petition. Kindly, my lords, I am producing the document that the trial court is relying upon. I am serving the copy to the opposite as well. If your lords may kindly have the document that I have filed before this court. As on 30th January 2025 itself, the earlier modified order was extended. I was also granted another Saturday and Sunday by the Hon. My interim order was extended for another 2 days. Along with Thursday, every alternative day, I was given video call access also. In fact, thereafter, your lordships, in the same writ petition that the trial court is talking about, had granted me overnight for the birthday of the father as well. Random, my lords, orders being passed without application of judicial mind, bald orders without even looking into the affidavits or applications, has become the trend. In earlier order, if your lords may kindly have the observation made by your lordships, the disposal, when the matter was disposed, your lords may kindly have page 10 of the list of documents that are, that's the final order that your lordships had passed on in that writ petition. Yes.
Page 14, my lord.
Yes, and my lords, I'll directly go to page 13, my lords, which is para number 4. Having heard the learned counsel on the either side peruse the entire materials on record in the earlier round of litigation also, this court has passed orders granting the visitation to the father, and there is no complaint that the boy is not comfortable with the father. Even when earlier bench interacted with the parents and also the boy, the coordinated bench of this court has observed that the boy is very comfortable with the father, and it is also an admitted fact that the both of them are staying nearby. In these circumstances, there cannot be an objection to the mother in granting overnight custody to the father. My lord, she had earlier put the child into an anath ashram where a meager payment was done, and she was just being busy with her work. Thereafter, he made an effort to ensure that the child goes to preschool from a very good school. And your lords have made an observation to that effect also, and I am paying maintenance in respect of his entire school education and the maintenance. Here, parties live less than 2 kilometers away from each other, and he is right now only having visitation of the child, that both mother and father have equal access to the child. And my lords, both are educated, and the petitioner herein is more educated, and he'll be able to take care of the child even better in terms of his education, also in terms of maintenance of the child. My lords, my prayer before the trial court was, if your lords may have the application that I filed before the learned trial court, that is at page 26, my lords. Yeah. The respondent above named respectfully prayed that for the reasons and the judge stated in the accompanying affidavit, the Honorable Court may be pleased to grant shared parenting custody of Arjun, aged about 3 and 5 months. Right now, the child is about 4 years and 1 month, my lords, as on the date of 23/1/2025, for beginning 15 days of the men, pending the custody of petition, and pass such orders as this Honorable Court deem fit. My lords, I have filed a detailed affidavit. She was before the court but did not file her objections. She did not even address her arguments. My lords, I have produced the screenshot of the order sheets which are in the chaos machine from page 23, my lords. If your lords may kindly have page 23. It is annexure C. The petitioner is absent. The petitioner is absent, the respondent are absent. The respondent side have filed IS 18 under section 12 of the Guardians and Wards Act for objections to IA number 18, 6-3. Almost 1.5 month time was given for her to file objections. My lords, on 6-3, the petitioner is present, the respondent is absent. For objections on IA number 18, call on 23. Again, another 15 days was granted time for her to file objections. If your lords may kindly have page 35. Heard the arguments from the respondent side, the arguments from the petitioner side is taken as heard and posted for orders on 9-4. Again, my lord, she had time till 9-4 to file her objections or advance the matter and argue or nothing. She did not do anything and an order is passed.
Yes.
My lords, these kind of orders need to be set aside in the interest and welfare of the child. My lords.
Yes. Yes.
My lord, if a lordship will notice the impugned IA number, it is IA number 18. Since the filing of the petition in 2023 on 20th of April, there have been 16 IAs filed by the father, only 2 from the mother. And that being said, my lord, the impugned order was passed on 9/4/2025 during the pendency of the previous writ as given by the petitioner in document number 2. Petition number 26399 of 24 connected with 25582. They have waited till the outcome of this petition and they were outcome fishing. Based on the outcome of this petition, they have decided to file the writ petition much later. They waited during the pendency of this proceedings to not file the other writ based on what the earlier outcome would be, so that they can accordingly adjust their grounds. And that being said, my lord, there are certain aspects of the main petitions in terms of their grounds which have been verified by the party. Lord?
Why did you not file your objections?
My lord, they filed 16 IAs. My lord, they filed 16 IAs.
So what?
And we had to respond to all of them. And in that point of period, we were placed ex parte. And the learned family judge has applied their mind and they passed these orders accordingly.
So then I'll also apply my mind and I'll set aside this order and I'll allow their application. What is that? What is that application? When an opportunity is given to you, you're supposed to file your objections.
Yes, ma'am.
And then if you don't file, that means you don't have any objection. Then we have to allow this application.
Well, the trial judge has seen the welfare of the child. As seeing, even though we were placed ex parte and we
you will not have the welfare. No, this litigation and this UNWC and MCA, all the parties are crossing all the limits. And now it has become a playground. Courts have become playground for them.
Well, there's filed 16 IAs.
So
and some of them have been overlapped. That observation has been made in page 23 of the main petition. Para 3, 6th line.
You are having overnight custody for how many days?
First Saturday, Sunday and third Saturday, Sunday, my lord.
When this order is passed?
My lords, this order is
2/7/25.
Then by the time this order is passed, now there is urgency for 50% of the.
My lords, once again. This order was passed on 2/7 only recently. I had filed this 50% application in January. On 9/4, the order was passed. But thereafter, as I have produced the document.
And the court has passed an order on 2/7/2025 granting you only some days as overnight custody. I do not see any reason to grant this.
My lords, but that application is absolutely different. That proceedings is a totally different.
Yes.
My lords, once again. Your lordships, we had not filed that writ petition at that point of time, because if your lords can see in the document that I have produced, back to back, these dates were coming up of the earlier writ petition. My lords, that is an independent application altogether. In fact, your lordships, I had an interim order where I was getting additional 2 days, and your lordships, that day when lordships, I had an interim order where I was getting additional 2 days, and your lordships, that day when disposing of the matter, mentioned that it was their writ petition and they have challenged. Therefore that interim order of video calls and the interim order of every alternative day that I had got also, your lordship did not entertain because that was their writ petition.
Yes, correctly.
Correct. My lords, that's why I have filed my writ petition. And that time I already had an interim order Other than the first Saturday and Sunday, I also had second Saturday and fourth Sunday. And I had every alternative day video call access for half an hour with the child. Suddenly that got abruptly cancelled on 2nd of July when your lordships
It was
passed
not
an order.
abruptly
One
cancelled, my
second,
lord.
when I am addressing
Advocates.
No, my lord.
Parties I can understand, parties of emotion,
Well,
but not the advocates, you're only representing them.
My lords, but
So
on
first of
second-
all, there is a way to address, I can understand, whatever is your case, both of you can present the case. Now, this case do not require this much of argument. I understood, but now either he will not come to the point nor you will come, both are going around the allegations against each other. Those allegations will not have any bearing on deciding this application because the court is not concerned with your or inter se allegations. Court is only concerned with the welfare of the child and looking at the age of the child. I understood what is the order that is passed by the court, what is that you are arguing and what is that he is arguing. Now I'll pass orders. Please come. Agreed with orders passed on. I number 18 dated 9/4/2025, whereby the court had dismissed an application that is filed
Lords,
seeking,
may I at least make a submission that let this court, honorable court, speak with the child. The child is so comfortable and wants to spend more time with the father.
this is not the time where he can have 50% custody. What did you write? Whereby the court had dismissed the application that is filed by the father seeking 50% of the custody. The GNWC petition is filed in the year 2023. It is a case of the father that the wife has forcefully took the child to the house and did not allow the husband that is WP number 26399 of 2024. An order was passed on 11/6/2025, whereby this court has passed an order that on 13/6/2025, after the school hours, the father can pick up the child from the school and drop the child back on 14/6/2025 evening at 5 p.m. Any inconvenience to the boy shall be informed to the mother, and if the boy insists, he shall be sent back to the mother. The earlier order with regard to maintenance, the father shall continue to pay. Then, finally, an order was passed on 2nd July 2025, wherein both the writ petitions that are filed by the father and that are filed by the mother were considered. And the order of maintenance that is granted by the family court is reduced from 20,000 to 10,000. And the order of visitation is more the order that's passed to the family court is modified, and this court has observed that in the earlier round litigation also the court has passed orders granting the visitation to the father, and there is no complaint that the boy is not comfortable with the father. Even when the earlier bench interacted with parents and also the boy, the coordinate bench of this court has observed that the boy is comfortable with the father, and it is also an admitted fact that both of them were staying in custody of the minor son for 2 days, that is twice in a month, that is on every first Saturday and Sunday, and on third Saturday and Sunday. On Sunday. This application was filed even much before the writ petition is pending before this court. The impugned order is passed on 9/4/2025, and the order in the writ petition is passed on 2nd July 2025. The interim arrangements that are made by the court are during the pendency of the petition, considering the welfare of the child and also the the interest of both the father and the child. The purpose of interim application is not to every now and then coming up with an application, because the party has a right to file the application. Now, when the court passes an order on 2nd July 2025 and confirms the order that is passed by the family court, wherein it is only the visitation is granted on the twice in a month, that is on every overnight custody is granted twice in a month, that is on every first Saturday and Sunday, and on third Saturday and Sunday. Now, at this stage, for a boy of 4 years, granting 50% custody to the child and filed. When the father and the mother, both of them are working, and every alternative week, father is having the overnight custody. And this court is not able to understand what is the pressing necessity for filing an application seeking 50% of the custody of the child, or rather a joint parenting for a boy who is aged about 4 years. In those circumstances, at this point of time, this court do not find any reasons to grant 50% of the 50% of the 50% of the custody to the father. However, as per the earlier order dated 2nd July 2025, father is having overnight custody on 2 days, that is on every first Saturday and Sunday, third Saturday and Sunday. Hence, on second Saturday and on fourth Saturday, father is entitled to have the custody of the child between 10 o'clock to 4 o'clock. Accordingly, the now no, first and third. Now this court has granted second and fourth. So what else he requires? The father can have the video call access on Monday. So no, Saturdays are on Wednesday. On Wednesday between 5 and 6. Right? Yes.
Final hearing, cell number 27. Nomini Rajesh Roda for petitioner Samaya.
Monday. Yes.
Cell number 28. Cell number 28. Arun Govindraj.
Huh?
Tuesday.
Tuesday.
Yes. Cell number 28. Arun Govindraj.
Lord, even I think I would also be making that same suggestion, Lord. That the first petition relates to, Lord, the custody, Lord. There is an interim arrangement which is in place, Lord, for 15 days each. That can continue, let the matter go back, because, Lord, it is at the stage of trial now.
We'll pass orders first on the first writ petition.
We are filing an affidavit to that extent.
Is it pertaining to the very same writ petition?
No,
that you're giving?
The affidavit is here, Lord. He has the documents. He has himself sent it by email.
Take that.
Please see.
This is their copy.
Have you given him a copy?
This is your copy.
Lord, we have attached the emails also, where he himself has sent these documents. Passport is there, my lord. The FRRO registration is there. Lord, we have also attached, my lord, the
Where is the influent order?
no order was passed.
The present petition is filed.
Lord, may I just make two requests? I'm making this request both on behalf of both the parties, my lord. When the children are with either of the parents, my lord, the other parent should have, my lord, time, my lord, some opportunity to make video calls, my lord, and that, my lord, and my lord, the mother, my lord, when the children are with the father, my lord, she may be allowed to meet them on any weekend. Yes, yes, I am saying same thing.
It apply to both the parties.
Yes, yes, my lord, I'm making this fair.
That's a modification. It's fine. Seeking the.
But I'm sorry, I'm interrupting. Just one more request. The daughter, my lord, is, my lord, scheduled for, my lord, admission in a school, my lord, where the son is studying already. But the father may be directed, my lord, to, my lord, sign the applications and, my lord, participate in the. Yes, but she was not of the age. Now, my lord. No problem.
That in 5 p.m. on Friday and 7 p.m. on Sunday during all festivals, and on the petitioner oblique his parents as also the minor children's birthday beside interim custody of the minor children for 50% of all the vacations, that is Samvat, Dasara, Deepavali and winter, and allow the petitioner further access to the children in the school. This court had passed several orders and several arrangements were made. The
Lordships may
arrangement
see, my lord, the order dated. Yes.
12.
110, I suppose.
This is 411.
No, that's.
This court has passed an order on 1/10/2024. Extract that order. Both the councils, the senior counsel appearing for the mother and the counsel appearing for the petitioner submits that both the pending disposal of the JNWC, both of them are happy with the arrangement that is made. However, in addition to the arrangement that is made, it is submitted that the father, either of the parents, when the children are in the custody of the other parent, on weekend, any day that is comfortable, they may be permitted to have access. Number one. Number two, the mother wants to join the daughter in the same school where the son is studying. For that, the father may be in school where the son is studying. For that, the father may be directed to sign the necessary documents, for which learned counsel appearing for the father submits that father is ready and all the formalities.
And participate in the interviews.
Formalities he will complete and participate in the interview. What is his problem? And also, not only meeting in between.
Holidays and Lord,
They can
festivals. Festivals and holidays, Lord, because Dasara and Diwali are coming. When Diwali comes, my lord,
Wherever they are, on the festival, on
no,
all
no,
vacations and all
on particular
birthdays,
Diwali day or something like that. my
all
lord.
birthdays, vacations, when whoever, when they are in the custody of the other parent, they are permitted to have the access on
Correct,
those
I know.
particular days, in the light of the arrangement dated 1/10/2024, and in addition to these three-year clauses, the writ petition is disposed of, and the family court, all other issues will be decided by the family court in the pending G&W.
Remains before the family court and whether the court should not spend any more time on this. Since we have an arrangement.
So the court will decide. No,
Let the court decide.
it's only, there are no, the interim arrangement is already made by this court. Now what is left to the court is to decide the main G&W.
Yes, Lord, only one request in this, Lord. That we can request if it is, if it is so. Lord, I'm only, Lord, making this request. On 20th and 21st, my lord, is Diwali, my lord. The mother wants, my lord, because during those days, the father will have the custody. Only for 20th and 21st of October, my lord.
No, but Diwali is also for him.
No.
So what
That is not, that's not.
during Diwali time, 20th and 21st, the mother can have access.
Yes, Dasara also, you can take. No problem, no problem.
Yes. No, it applies to him also. When on other festival, when the children are with the mother, father will have the access.
One second, please.
Cell number.
My lord, there are two other writ petitions.
That I'll be looking
Yes.
at. This is the first writ petition. Yes, next.
Lord, the two other writ petitions.
Yes, in the light of the order dated so and so, and also the further modification, additional, the same impugned order.
Same impugned order, Lord,
Maintenance
order.
Please come to the order now.
Lord, how can you ask me to appear like this without the fact?
Directing the respondent to produce documents. On the same day, the family court directs you to pay.
Lord,
The documents have not been placed on record.
no, it's all been placed on record, my lord. We have produced before this court
No,
also.
what we do is.
But what I'm saying, Lord, we just, if your lordship permit.
Before that, whatever is the arrangement that is made here,
Yes, ma'am.
that shall continue.
Continue, my lord. That
Till
was
the
my
application
suggestion.
is decided by the family.
That was
court.
my suggestion also, my lord, that let that arrangement continue. Number
Where
one.
is the order for that arrangement of amount?
Lord, that is 110, my lord.
Same order, in the
Yes,
same
yes,
order.
my lord.
110 order.
110 order, my lord.
Just not the. No, where is the order directing you to pay?
Lord, on what? Lord, on.
No, not 110, the impugned order, where do you get, 1,50,000.
Lord, this order, my lord, Lord, I think we are both added in, my lord, that this was heard without, this was passed without hearing the particular IA. On only that ground, my lord, it can go back.
So where is the amount? It is, yes. The father shall pay an amount of
please, I know.
5/10/2024 without going into or considering any of the contentions raised on behalf of the parties. 2 lakhs shall be paid to the mother. So the father is taking care of the educational expenses. So and so. Mother shall be shifting the premises where the rental expenses is lesser than ₹1 lakh. Yes. The writ petition is filed, questioning the order dated. Order on I number 2 in criminal miscellaneous number 662 of 2023, dated 19/10/2020.
2024.
2024, whereby the court had directed the father to pay 1 lakh per month towards the rent, maintenance and other expenses. Whereby this court had directed the father to pay 2 lakh to the.
No. 1,75,000, my lord.
I think
Your
that is
lordship
not the
will see
order.
para 4.3.
That is, thereafter there was modification. 411. On 4/11/2024.
Point number 2, para 4.
3.
On 4/11/2024, this court had directed an amount of rupees
4 and 5 also. Sapara.
Directed the father to pay an amount of rupees 1 lakh towards rent and an amount of rupees 75,000 per month towards the maintenance of the children, and the father, and he shall also pay the educational expenses as per the earlier order.
By 5th of each month.
By 5th of every month. It is the 5th of every month. 5th of every month. Both the parties submit that. Now, they will be filing all the relevant documents before the court.
It's already filed.
My
Lord, the objections may be considered by the court, my lord.
submissions were not.
What, because it's.
Those
before the
objections
lower
may be
court.
considered.
Whatever it is filed before the
Correct.
court. It is submitted that both the parties will file their respective documents, the relevant documents before the court. And the court may be, the court may hear the IA on merits suffrage. Considering the same, the order impugned dated so and so is set aside, and both the parties within a period of 15 days from the date of receipt of the copy of this order shall file all the documents as per the judgment of the apex court in Rajesh versus Neha, and the court shall hear the application and pass appropriate orders within 2 months from there on. Till such time, the arrangement with regard the arrangement made by this court, that is paying an amount of rupees 1 lakh for the 12th of every month, and the father shall continue to bear the educational expenses of children. Then whatever in
all
the light of
contentions
this,
may be left
both
open.
all the contentions are over.
Lord, and Lord, if necessary, Lord, we can apply for modification of this arrangement.
Which arrangement?
Lord, this arrangement, if
No,
there is
no,
any need.
because it is
Correct,
only
they are
2 months. So let there not be
No,
another
I'm
IA.
saying, not before this court, Lord.
No, before that court
Before the
also.
family court only.
It's only 2 months. I've given I fixed a time frame to dispose of. So in 2
Let
months,
this
what
not
is
be
the-
written in stone is all I'm saying.
No.
This arrangement should not be
No,
said.
it is only for 2 months because it's going to be decided. In between, another application is.
No, for that I'm not saying anything.
Yes. Yes, according in the light of the same, both these writ petitions are disposed of, 28.1 and 28.2. Yes.
President was also being very fair about it. Visitation. My
I didn't know that.
No, with both efforts of the councils, it could happen.
I'm
grateful for it.
obliged.
Yes.
Number 2.
Yes, list number 2.
List number 2 for dismissal, Sohani Holla for appellant, Naveen Kumar.
Yes, sir. Where is Naveen Kumar? Paso? Paso? Paso. Yes,
Serial
next
number
matter.
2,
Serial number 2, I appear for the respondent, my lord.
Mohan
Where is
Chandra.
he?
Respondent is actually not seriously suffering with the kidney problems.
Yes, 2:30. Not 2:30, when the passovers are called. Yes, Sri.
Serial number 3,
Memo is filed seeking dispensation of notice to R1 dispense with at the risk of appellant. Where is Pradeep?
Pradeep B.
Yes. Yes, Pradeep, what are the injuries?
Lordship only request for pain and suffering and amenities because he is continuing the same job. Lordship could have announced that pain and suffering and amenities.
And also disability had may granted
Disability
because 39%
That will come under disability, that will come under loss of amenities.
Loss of amenities.
That will
That is
also
the two,
pain and suffering,
that's
how
two
much?
Lordship is into.
How much? Pain and suffering.
Madam, fractures are fractures of right femur, fracture of right acetabulum, fracture of radial and ulnar styloid process, and laceration of spleen, my lord. 4 fractures are 3 or 4 fractures are there.
That's what my lord. 50,000 addition in amenities and 50,000 addition in pain and suffering. Lordship could have disposed.
Pain and suffering will grant 1 lakh, attendant charges as it is. Loss of future amenities.
That's what my lord is continuing the
Another
same.
50. That is 1.
1 lakh. With interest 6%. my lord.
And doctor stated 4 lakh for future medical expenses, 50,000 is given, it may be enhanced.
Future medical
Because of
expenses.
that, my lord, change of acetabulum, my lord. Doctor stated
So that
There is a facility of reimbursement also, my lord. Any of my lord,
Percent,
50,000 future medical expenses has already awarded. They have not produced any estimation of why their need for 4 lakh. The oral testimony of the doctor, my lord, it was stated that 4 lakh is required.
change of acetabulum, my lord. Reimbursement is 50% is reimbursement, my lord. Only medical bills. And another 50% paid by
any
me.
evidence in that regard.
No, my lord.
Then
Loss of disability may some amount may be awarded, my lord, because 39% disability.
But we have granted under
2 years,
MLT
my lord, only 2
another
years.
50,000.
Only 2 years. So another one, my lord, loss of disability may award some amount, my lord, in that. Because he has 34 years, my lord, he has, at the time of the accident. Young age, my lord. And sustained 4 fractures, my lord.
Future medical amenities, future medical expenses we will grant.
70
It is
plus
7,06,000 is what is granted. 140 plus 10,000 is there for legal expenses. 150.
Yes, 100.
Then it
My
becomes.
lord, 1,50,000 for 70 plus 30 plus 50 amenities, my lord.
1,50,000 only.
That's what I am saying. So it becomes 8,56,000. Agreed with award passed in embassy number 318 of 2017 dated 6th March 2020. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the injuries sustained by the claimant. The tribunal has awarded the compensation as per the table given below 25. Land counsel appearing for the claimant submits that he had sustained 6 fractures or 4?
4 fractures.
4 fractures, and the head of pain and suffering court had not granted a reasonable amount. Then it is submitted that when he had sustained disability of 39%
to limb, my lord.
to the limb, court had not granted any amount at the head of loss of future earning. Further, for the future medical expenses and also loss of amenities, the amount that is awarded by the tribunal is not just and reasonable. Next parallel, and counsel appearing for the respondent insurance company submits that the court, the petitioner is continuing with his work a medical reimbursement facility. It is submitted that the court under all the heads has granted a reasonable amount and no enhancement is called for. Next parallel. Considering the 4 injuries that were sustained by the claimant and the head of pain and suffering, this court is granting 1 lakh towards attendant charges. Court had granted 25,000. No interference is called for. Coming to the amenities, considering the fact that there is a disability, but considering the future 10,000, altogether the claimant is entitled for an amount of rupees 8,56,000. Accordingly, the compensation of the appeal is partly allowed by enhancing the compensation from 7,06,000 to 8,56,000. Yes.
That's say number 4. I pay for the appellant, my lords. I have deposited 8,24,000 as directed by the court. The matter may be referred for mediation, my lords. We will try to explore positive settlement, my lords. Since the driving license was
who is R3? Who is R3?
The insurance. But since the driving license was not there, my lords, the compensation is fixed on the owner. And duly I have deposited 8,24,000 before this court, my lords, as directed on 25/1/2021.
Whether the presence of R3 is required or not.
That's
you will be.
It's for Tokyo.
Yes. Yes. Whether the presence of R3, notice to R3 is required or not.
Hello, sir.
My lords, in case, my lords, in the mediation, if the R2, my lords, does not agree for this amount, then, my lords, I have to come back before this court and argue that even though there was no driving license, the liability should not have passed on me.
It is submitted that there is a scope for settlement. The matter is referred to the Lok Adalat. Yes.
That's mediation, my lords, before the High Court, my lords, will try.
High Court Mediation Center. Yes, next 5.
Case number 5.
That's interim order make candidate.
I'm for appellate in this case, my lord. The liability is on R1, my lord, so I had to take notice. Owner of
Who is R1?
R1 is the owner of the auto.
So appeal against R1 is dismissed.
Yes, my lord. 50% of the amount to be deposited, 50% has to be forgo.
The peremptory act of previous date, sir, because you have not taken the steps.
I'll file application to
Whenever the matter comes, it's very unfortunate, Mr. Abdul Sabur. You will say, you will not even look, what is that? And court has to tell you that appeal is dismissed Then you will say you will come up with application. It's so unfair. This is matter after vacation.
Serial number 6. Radha BP.
Appearing for appellant in this case, my
Kindly
lord.
post along with MFA number 7879 of 2022.
Yes, post along with.
My lord, it may be posted for admissions, my lord. All the office objections have been complied with.
What will happen if it is here? There are so many objections. Copies to issue notice to R5 for third time.
My lord, notice has been dispensed with, my lord, because
Where is that?
notice had been sent in the connected matter, my lord.
Where is it dispensed with? How can it be dispensed with?
There are so many office objections in MF 970.
List along with so and so under the same caption.
Serial number 7.
Therefore, appellant, my lord.
Malikarjun. MP Raika. Alice.
Yes.
Trial court, my lord, dismiss the claim petition against the respondent member insurance company on the ground that not the driver of the offending vehicle is company on the ground that not the driver of the offending vehicle did not having two-wheeler driving license. He having, my lord, four-wheeler DL. That is the finding.
So if you have four-wheeler, you can drive two-wheeler.
DL. That is the finding.
So if you have four-wheeler, you can drive two-wheeler.
It can't be.
For R1 notices.
For R1, my lord, notice, I am fine. Even though before the trial court, he was expert in that.
On that ground, you are filing me. Take that. A memo is filed stating that the R1 is set ex parte before the trial court. Hence, notice to R1 may be dispensed with. Yes, memo is taken on record. And notice to R1 is dispensed with. I number 1 of 2023 is filed to condone the delay of 2. Yes, nothing to enhance in this.
No, my lord. The income taken by the trial court, my lord.
No. Pain and suffering not reported.
Please, sorry.
How many days he was in hospital?
18 days, my lord, sir.
18 days.
Please.
18,000. Medical expenses as it is.
Please.
Then.
Amenities, my lord.
Which year is the accident?
2020, my lord.
Court had taken?
9,000, my lord.
How much it should be?
14,500, my lord.
14,000?
500.
Four months?
Please. Court has taken 2 months, my lord.
What has considered only 2 months?
Huh?
What has considered only 2 months?
By taking 9,000 income.
58,000. Then medical expenses.
58,000.
So one is future medical expense. And another is medical expenses.
Please. Yes, ma'am.
1,54,000. Then what about this loss of future income?
Future income, my lord, considering 9,000 income, 10% disability, 5 multiplier, 67 years.
14,500 into 12 into 5.
5.
Into 10.
10.
Whole body limb disability is 30%.
Please. Whole body 10%.
$87,000.
It's coming to 4,65,000. 3,74,000. Please come.
So far as liability is concerned, my lord, hardship could
Pain
have
report.
paid.
The the agreed with the award passed in embassy number 1076 of 2020 dated 31st March 2022, whereby the court had granted compensation of an amount of rupees 3,74,000 The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the injuries sustained by the claimant in the road traffic accident. The tribunal has granted the compensation as per the table given below at paragraph number 14 extract. Then counsel appearing for the petitioner submits the seeking enhancement and also questioning the liability fixed on the owner of the vehicle. Then counsel appearing for the claimant submits that as the driver was not having a valid driving license, the court has fixed a liability on the owner of the vehicle. He submits that in the light of the law laid down in Saran Singh's case, the insurance company is liable to pay and record the same from the owner of the vehicle. It is submitted that when he was in hospital for 18 days, court had granted only 10,000 at the head of nourishment. Further, it is submitted that the coming to the loss of earning during the leader period when it is a femur fracture, court had granted when the accident had taken place in the year 2020, court had taken the income at 9,000 as he was set ex parte before the trial court. Next person, having heard the counsels on either side, peruse the material on record. Under the head of pain and suffering, medical expenses, future medical expenses, and the medical expenses, and the loss of amenities, court had rightly granted the compensation. No interference is called for. Coming to the nourishment, the incidental expenses are concerned. He was in hospital for 18 days, and this court is granting 18,000. Coming to the loss of earning during the later period, considering that it is a femur fracture and considering the income at 14,500 into 4, this court is granting 58,000. Coming to the loss of future income, 14,500 into 12 into 5 into 10 by 100 is 87,100. In the light of the law laid in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,65,000. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,74,000 to 4,65,000. Accordingly, the appeal is partly allowed. The enhanced amount shall carry the entire amount shall carry 6% interest.
And recover.
And the insurance company shall pay and record the same from the owner of the vehicle. Yes. Don't remove. I was.
One submission, my lord. Serial number 6. One submission, serial number 6.
Hello, sir. Vijay Kumar, sir. Already attended along with the.
ಅಲ್ಲ ಮೇಡಮ್ ನಾನು ಇದು ಸಬ್ಮಿಷನ್ ಅಂದ್ರೆ ನನ್ನ ನೇಮ್
ಅದು
ಡಿಲೀಟ್
ಅದರಲ್ಲಿ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಒಂದು MFA.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ನೋಡಿ. ಅಲ್ಲ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ನೋಡಿ. ಅಲ್ಲ ಯಾರು ಪಾರ್ಟಿ ಯಾರು ನೋಡಿ. ಐ ಆರ್ ನಾಟ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಸೀರಿಯಲ್ ಇದು.
ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಗೆ R1 ರಂಗೇಗೌಡ NR ಇದ್ದಾರೆ.
ಬಟ್ ನನ್ನ ನೇಮ್ ತೋರಿಸಿದ್ದಾರೆ.
ಅದು ನಿಮ್ದು ರಾಂಗ್ ಆಗಿ ತೋರಿಸಿದಾರಾ?
ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡ್ದಕ್ಕೆ ಹೇಳಿದ್ರೆ ಮೇಡ ಸಬ್ಮಿಷನ್ ಕೇಳಿದಾರೆ ನಾನು ಎಂತ ಮಾಡ್ಲಿ.
ಹೌದಾ?
ಅನ್ನೆಸೆಸರಿ ಬರ್ತಾ ಇರುತ್ತೆ ಇದು. ನನ್ನ ನೇಮ್ ಡಿಲೀಟ್ ಮಾಡಿಸಿ ಅದು.
ಅದೇ R2 ನಲ್ಲಿ R2 ರಂಗೇಗೌಡ NR ಇವರು ಇನ್ಶೂರೆನ್ಸ್ ಕೇಸ್ ಹಾಕಿಸಿ ಆಲ್ರೆಡಿ ಇದ್ದಾರೆ. ಟು ಪ್ರೈವೇಟ್ ಪರ್ಸನ್ ಕ್ಲೈಮೆಂಟ್ ಇದ್ದಾರೆ. ನೇಮ್ ಅಂತ ಡೆಲೀಟ್ ಅಂತ. ಹೇಳಿದೀನಿ ಸರ್.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
ಆಯ್ತು.
ಥ್ಯಾಂಕ್ ಯು.
Give you the list.
One respectful submission, my lord. One respectful submission. My lord, I appear on serial number 15, list 1, my lord. My lord, one clarification, my lord. When the matter was taken up in the morning, your lordships may recall, your lordships was pleased to hear the matter in the next week, my lord. But the order sheet reflects the date 15/10, my lord.
I said next week. Yes. No, 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 no. They are asking for after vacation. I said next week. Then they were bargaining on the date, 50 Tuesday, Wednesday.
Any date, your lordship.
24? I clearly said so. Yes.
I'm
Continue.
grateful, my lord.
Continue the list.
Appellant, my lordship. Now I am filing my memo for dispensation in both cases for R1 and R3, my lordship. They are the ex parte before the trial court.
Memo is filed. 2 memos are filed. Second dispensation of notice to. Why 2 memos for R1 and R3?
No, ma, 2 appeals are there, my lordship.
Oh, memos are filed. Second dispensation of notice to 1 and 3. It is stated that they were ex and 3. It is stated that they were ex parte with the trial court. Memos were taken on record and notice to the R1 and R3 is filed to condone the delay of 388 days, condoned on condition.
It's a case of death.
Then IA number.
Case of death.
But they have to be ready. If they're ready, I'll take up. Are you ready? Yes, after vacation. What is this discrepancy in the name of appellant number 2?
In judgment, the spelling mistake is
Whatever
Apurva.
mistake that is committed, you should carry on in the cause title here also.
In award is correct as per award.
Very
Apurva, page number 22.
Hmm.
Apurva is correct as per
22. Appellant's name is
Apurva.
Apurva.
In judgment, spelling mistake.
The office objection is overruled. Yes. What is this matter about?
Case of death for enhancement.
What is the age?
Age 47 years.
Date 17/3/2020. 2020 is the accident.
Yes.
How much what is the income taken by the
10,500.
10,500 was taken by the court.
Yes.
Huh?
14,500.
No, 14,000. Court has taken 10,500. 14,500. And
Plus 25%.
25% future prospects. That was not taken?
Not considered.
Considered. Only with regard to the income. How many are the dependents?
Five members.
5.
Wife, 2 children and parents.
1/4.
Please.
What is the multiplier?
11. Sorry, 13. 13.
So loss of dependency is coming to 16 lakhs, 96,500. Loss of consortium, 5 into 44. 2,20,000. 36,000. It's coming to 19,62,500. Please come. Agreed with the award fast, right? MBC number 549 of 2020, dated 24th March 2023, whereby the court had granted compensation of an amount of rupees 11,58,155. The claimant is before this court seeking the enhancement of the compensation. The age of the deceased is 47 years as on the date of the accident. And the court accident has taken place in the year 2020. The court had taken the income at 10,500 and had granted the compensation. Where is the compensation? Where is the table? Table is not there.
73/2020.
Table.
Table not mentioned.
Look at the synopsis table. Will have it. Synopsis. Table is at this. What is this? What is the amount that is granted?
Generally, 30% contributory negligence is deducted. Is a decision.
The land counsel appearing for the claimant submits that the accident has taken place in the year 2020. Court had taken the income at 10,500, and as per the table, it ought to have been taken at 14,500. It is submitted that even in the conventional heads also, the amount that is awarded by the tribunal is not just unreasonable. Next, land counsel appearing for the respondent insurance company submits that the court had rightly granted the compensation. No enhancement is called for. Next para. The accident has taken place in the year 2020, and as per the chart, the income is 14,500. Plus, considering the age of 47, future prospects at 25 comes to 3,625. That is 18,125. As there are 5 claimants, 1/4 has to be deducted to the personal expenses. It comes to 7,250. If the same is deducted, his contribution to the family would be 10,875 into 12 into 3. The loss of dependency is 16,96,500. Towards loss of consortium, 5 into 44, 2,20,000.
18,125. 1 part deduct 13,594. Sir. Please.
Not followed.
Please come. 36,000 towards funeral expenses, and 10,000 in the light of the law laid down in Mekala versus so and so towards legal expenses 10,000. That is the 19,62,500 as 100. This court do not find any reasons to interfere with the finding of contributory negligence that is fixed against the claimant. So from 19,62,500, 30% is 5,88,750. The same is deducted. The amount that is payable by the insurance company is
Interlocutory applications. And the right of
Item number 1 of 23 is filed to condone the delay of 457 days, condoned on condition. Yes.
My appeal seeking for enhancement of compensation.
What about your appeal?
The claim is made by the married daughters.
Filed by?
Daughters.
Married daughter.
Wife and married daughters. The tribunal has deducted 1/4. Is the only
income.
The only grant.
Let's see the cost item.
The petition number 2, Gangamma, she is married to one Jagdish. Mamasamma is married to Hanumantappa. Renukamma is married to Nagireti.
It should have been one third. One third. We'll deduct 1/3.
Birendra Singh judgment, even though married daughters also they are entitled.
The subsequent judgment of the Supreme Court. The subsequent judgment of the Supreme Court says that the married daughters are not entitled for the loss of dependence. The judgment which was delivered in the month of July.
Yes. What is which year is the accident?
2019, my lord.
2019.
2019.
Please.
Income was taken at
10,000.
10,000.
Please.
It should have been 14,000.
Please.
He was aged around 65 years.
60?
65.
He is not entered
Second
future
multiplier, no future prospect.
Then Dependent, how many are the dependents?
Five.
1/4 has been deducted, it
Please.
should be 1/3.
Should be 1/3. Comes to 7,84,000.
7,80,000. It's coming to, loss of dependence is coming to 7,83,972. 5 into 44.
44.
2,20,000.
Court has awarded 2,15,000. So court awarded 2,60,000. 2,45,000. Total.
It's coming to 10,49,972. How much is awarded by the court?
8,83,000. 8,83,000.
Please come. Agreed with the award passed in MFA, MBC number 16020 of 2020, dated 19th March 2022. Both the insurance company and the claimants are before this court. The claimant's appeal is MFA number 6493 of 2023, and the insurance company's appeal is MFA number 7042 of 2022. The claimants are the son, wife, and the daughter, and 3 daughters of the deceased. The tribunal, considering them as a dependents and taking the income at 10,000 as the accident has happened in the year 2019, had granted the compensation as per the table given below at 23. When counsel appearing for the claimant submits that the court ought to have taken the income at 14,000, instead of that, court had taken 10,000, deducted 1/3. That is up.
1/4 is 1/4.
Deducted, it should be 1/3. 1/4 instead of 1/4, it should have deducted 1/3. It is submitted that the compensation that is awarded by the tribunal is on the higher side. The same needs to be reduced. Next para, having heard so and so, so and so. The accident has taken place in the year 2019. Hence, this court is taking the income at 14,000. The claimants are 5 in number: son, wife, and 3 married daughters. They cannot be considered as the dependents of the deceased. Hence, this court is inclined to take 1/3, deduct 1/3 towards the personal expenses. It would come to 4,666. Then his income is, his contribution to the family is 9,333 into 12 into 7. Then it comes to a loss of dependency would come to 7,83,972. Towards consortium, 5 dependents into 44, 2,20,000, 36,000 towards funeral expenses, 10 towards legal expenses. The claimants are entitled for an amount of rupees 10,49,972. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 8,83,000 to 10,49,972, and the appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transferred.
Till delay of 480.
They are not entitled for the delay of 482 days.
450.
That's already I told you, no, that order, consideration of. So they are not entitled for that period. Yes, next.
Cell number 11. Kalpana PV for petitioner.
Yes.
Appellant.
Yes.
The first appeal is preferred by the owner of the vehicle, my lord.
Went before the police and stated that he was working as a lorry and that lorry was, there is some technical problem, lorry was stopped, the mechanical problem and so on, so date. He has boarded the trailer, tractor and trailer to go to some other place.
Then what is the finding of the court?
Same finding as given. He is not the loader and unloader.
He is a gratuitous
They have
passenger.
suppressed the material fact and impeached reports also they have not produced. We have produced the impeached report. That is also amply demonstrated that he was not working
and held that owner is liable.
tractor and trailer, they are not working under the owner of the tractor and trailer.
Yes. What do you say?
Lord, in this case, my lord, the on-record counsel is under the interview, my lord. Kindly have this matter tomorrow, my lord.
Not tomorrow. Give the date next week.
23/9.
Yes.
Serial number 12.
At the request of learned counsel appearing for the owner. Yes, 12.
Serial number 12. Pradeep B. For appellant. Suma K.
You're on what ground?
Quantum.
All are on quantum.
Quantum. I am challenging the quantum of compensation on the ground that, my lord.
No. There are this.
My lord, arising out of MEC 73 of 18.
Next one.
Next one, my lord, 174 of 18, 2650 of 22.
174.
174 of 2018, MEC, MFA 2650 of 22. In both the cases, they filed cross objection.
Cross objection.
Cross objection.
Yes.
Our main grievance is that, my lord, they are the income tax assessing, my lord. They are doing the business and running the printing press. Subsequently, to the date of accident also, they were.
Come to that.
Please, my lord.
First, let us look at this MBC 173.
12 to 20, my lord, they have filed the returns. Subsequently, the date of accident also, the income has been increased. There is no question of granting loss of future earnings would arise as for consideration. Loss of future earnings, I am challenging.
Only on that ground. Let's see the table. Where is it?
Please. Table is, my lord, para 20.
What do you say on loss of future income?
If you see exhibit P13 and P14, there is a decrease in income. See, what happens is when a person suffers a disability, the doctor says if it is 10% disability or 30%, here in this case it's 30%. So what is the effect to the nature of the work? Here he was running a printing press. So what has happened is he has suffered two major injuries and doctor has told that he has permanent physical disability of 30% and he cannot work like before. So in the printing press, what he has to do is he has to get the papers, he has to print it, he has to visit the client's office. So when this 30% disability is taken, and in exhibit P13 and P14, if I point out, there is a decrease of income. When I have a business, there should be a consistently increase of
Yes, what do you say? She says as per the document, there is decrease. You say there is increase.
No, my lord, kindly see the exhibits.
What are the exhibits?
Please, my lord.
Take the is here. Exhibit?
P13 and 14.
Exhibit?
P13 and 14. He is having 5,71,744.
On exhibit P13.
13. And P14 is having a decrease, 5,17,960. Your Lordship, when it's a business, it has to be consistently, it has to increase.
Kindly turn to next page, my lord.
Next is 5,40,000. It is increasing.
It is very,
Increasing.
it is a very marginal.
And next, my lord.
Because he has to do all the activities.
5,92,000.
Please.
625.
6,81,000. Next. There is no increasing the annual income.
My humble submission is that when a person.
Yes.
When a person who has to do the work, he has to do in a printing press, he has to do all the work, he has to take the paper, he has to go to the clients, etc. That will affect compared to a person who has no disability. Here the trial court assessed 30% disability and they have taken only 1/3 of it. Hence my humble submission is that may be retained.
Yes. What are the injuries?
Injuries, my lord. Comminuted fracture of tibia and fibula. Fracture, dislocation of tarsal bone. That's
3.
3.
Court has granted 70.
70,000.
Nothing to increase in this. Then loss of amenities. It
Milord,
is
laid up
10%
period,
disability.
laid up period 85,000 awarded.
Huh?
Laid up period.
No, that will go. This loss
Please,
of amenities.
loss of amenities, my lordship may increase. Another 35,000.
What do you say about loss of income during later period?
Granted 85,000 rupees. my lord.
Income is 5,71,000. Another 10,000. 95,000. How many days he was in hospital?
9 days. my lord.
What about the next matter?
Next para 21. my lord.
MBC is 170.
173. my lord.
173 is over now.
Over 174. my
174.
lord. Next 174. Para 21.
Hmm.
This case also same, my lord. The income tax which has been produced before the court
Hmm.
in the year of 2014 to
48 and 49, exhibit 48 and 49.
So paragraph number,
22. my lord.
table. What is the disability according to the doctor?
35%.
Huh?
35% of the limb, my lord.
35% to the left lower limb.
This is also 50,000. Loss of income during later period. What is his income, annual income?
Annual
His annual
income as
income is,
considered, my lord.
first annual income is 41,913 was taken for the first. For this, it is 64,006.
How many days he was in hospital?
9 days. my lord.
Same 9 days.
Same.
Hmm.
64,006 into 3, my lord.
Doctor has said that it is still, it's a permanent physical disability of 35% and fracture is malunited in both the cases.
Then what about the income tax returns in this case?
This case also, my lord, same thing, my lord. It is increasing only.
In 2014, how much it is?
Please. 2014, 15 million financial year, 8,30,821.
8 lakh?
30,000,
Hmm.
821. My lord, after deduction of tax, 7,68,000. 078.
You tell the before tax 8,30,000.
821.
You tell the before tax 8,30,000.
821.
821. Then next year,
Next year, also, my lord, it is increased.
Your Lordship, 48 exhibit, it is 61,858. 61,858. And the next year it is 5,75,380.
what 61,000?
60.
6
6 lakhs, my lord.
18,658.
In 2014, how much it is?
2000 on 38 2013 it is 6,18,658.
6 lakh?
6,18,658.
Then
Next year it is 5,75,386.
Then 16. Next year.
15, in the year 15, it is 8,30,000 for 821. In the year 2016,
There is increase in the income. Yes.
in lakh. 8 lakh. 1 lakh. 15 lakh.
Please come. In this case, no medical expenses.
There, my lord, 39.
1 minute.
My lord, 39,040, my lord. 6, serial number 6, my lord. Next page, 25, internal page.
Yes, I've seen. With the award passed in MVC number 173 of 2018, 174 of 2018, dated 24/11/2021. The insurance company is before this court by filing MFA 4444 of 2022 and MFA 2650 of 2022. In that, the in MFA 4444, the claimant has filed MFA crop 20 of 2023, and in MFA 2650 of 2022, the claimant has filed MFA crop 21 of 2023. When counsel appearing for the insurance company submits that though they have sustained 10%, the sustained disability, but that disability had no impact on the income of the claimants. It is submitted that the income tax returns, though accident has happened in the year 2014, they have been filed till the year 2020, and the Learned Counsel has drawn the attention of the court to the income tax returns. Learned Counsel has drawn the attention of the court to the income tax returns, where it shows that it's a consistent increase in the income of the claimants. It is submitted that the court, without considering this aspect, had granted the compensation under the head of loss of future income, and the same to be and that needs to be interfered by this court. Then counsel appearing for the claimant submits that they are doing printing business, and the disability, as assessed by the doctor, it would have an impact on the business of the claimants, and court had rightly considered and granted the compensation. It is submitted that under the other heads, the compensation, that is for the loss of first side heading MFA MFA 4444 of 2022, arising out of MEC number 173 of 2018. The court had granted the compensation as per the table given below. Extract the In both the MVCs, the contention is with regard to the future loss of income. This court has perused the income tax returns that are placed before the court, as rightly argued by the rent counsel for the insurance company. There is consistent increase in the income of the claimants. The tribunal, having considered the income tax returns, ought not to have granted the compensation under the head of loss of future income. However, the amount that is granted under the head of loss of amenities and the loss of income during the later period was not reasonably granted. Hence, under the head of pain, as far as pain and suffering is concerned, court is rightly granted. Coming to the loss of amenities, this court is granting 50,000. Loss of income during the later period, 95,000. The medical expenses, attendant, diet, and the incidental expenses are rightly granted, and no interference is called for. In the light of the law laid down in May clause so 10,000. Altogether, the claimants are entitled for an amount of rupees 3,03,851. Accordingly, the appeal of the claimant is partly the company, they are at liberty to withdraw. Next, MBC 174 arising out of MFA 2650 arising out of MBC 174 of 2018. The court had granted the compensation as per the table given below at paragraph number 29. Even in this case also, the court had granted the loss of future income, and the income tax return shows that there is consistent increase in the income. Hence, the claimants are not entitled for any compensation under the head of loss of future income. This should be there in the other one also, that the claimants are not entitled for. Under the head of pain and suffering, this court is granting an amount of rupees 50,000. Loss of amenities, 50,000. Loss of income during the later period, attendant charges. This court is not, and medical expenses. This court is not interfering. Legal expenses in the light of so and so 10,000. Altogether, the claimants are entitled for an amount of rupees 2,92,040. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 14,74,389 to 2,92,040. Same. Enhanced the amount in deposit, and any excess amount shall be withdrawn. Yes, shall be withdrawn. Yes, consequently, prop number 21 of 23 is this. Yes. Doesn't matter. IA number 1 of 23 is filed to condone delay of 145 days in filing the crop. The same is considered, and delay is condoned. Yes.
Loss of amenities and pain and suffering is just increased a bit.
Increased 50,000 there. It is increased.
Because 2 fractures were there. If it is made to 1 lakh each, then at least.
So, in both the cases, pain and suffering, make it 1 lakh. So, in MBC is the 174, it becomes 3,42,040. And in this, only 30,000 will be added because it is already 70. 1 lakh is 30,000.
Lordship can make it under pain and suffering 1 lakh.
That's what in both the cases, pain and suffering after increasing 3,33,851. Just count it again. Yes, next. Okay. Yes. Yes, next.
Cell number 13. Cell number 13.
Yes.
Guru Prasad BR.
Please, ma'am. Last week, this matter was listed, my lords. It is a case of the wife of the deceased has filed one claim petition, and the mother of the deceased has filed another claim petition. Both were clubbed together.
What happened?
My lordship, we have no
access towards the claim, Your Lordship, and we could.
We'll issue notice then.
Yeah, please, my
We'll issue
Lordship.
notice to the party.
Yes.
Please, my lord, for 2 and 3, note, it may be dispensed, my lords.
Take that.
2 is the owner and 3 is the father of the deceased and no.
Where have you shown this in your appeal?
Please, my lords.
Which is the respondent?
My lords, in page number 3, ink page number 2 and 3.
3.
1 is the insurance company.
Yes, 1 minute.
2 is the Vijayananda Shetty, he is the owner of the vehicle, my lords. 3 is Mr. Krishna Suvarna, he is the father of the deceased. No award has been made in his favor and he has not challenged it. For 2 and 3, I am seeking dispensation. 4 is the mother.
I'm asking about the other appeal. You have not shown them as a respondent to this appeal?
I have shown fourth.
Serial number 14.
Any urgency for you?
I am Venkatesh.
Any urgency for you? Huh? List is matter in the month of December, no representation for the appellant. This is matter immediately after vacation.
Yes.
Yes, 15.
Serial number 15 for final hearing.
It can kindly be taken up on Monday, my lord. Linga is held up in court on number 5.
We can take it after vacation? Huh? Yes, list is matter next week. Give some date.
Is 25/9.
Please.
Yes, 16.
Serial number 16. A. Krishna Swami.
Appealing the appellant, my lordship. My lordship, appeal preferred by the insurance company, my lordship. Only one ground, my lordship. That is income assessment erroneous, my lordship. Because of exhibit R2 showing that 13,000. As per the policy, my lordship, and before amendment, it was sealed for 8,000 rupees, my lordship. So there's only one ground, my lordship. And remaining balance should pay the owner, as well as the interest part, my lordship. They should only pay, my lordship.
Come to the award. The petitioner, which is also compensation of 8,34,000 with interest at 12% from the date of petition till the date of payment in proportion of 40, 20, 10, 20, 10. What is this?
My lordship, accident occurred on 1/2/2018, my lordship. He's working as a cook. And despite of circular number 17, my lordship, the petitioner has produced the document in support of age disease, but respondent number 1 and 2 have produced wage slip, which match exhibit R1 and R2. The perusal of exhibit P6, that is postmortem report, it reveals that deceased was aged about 57 years. At the time of accident, in affidavit PW1, he deposed that the deceased was getting wages of rupee 15,000 per month. But in order substantiate this exhibit R1 or R2 produced, I find that it is just unnecessary to consider income deceased has 13,000 per month has exhibit R2. But as per insurance policy, it's sealed for 8,000 rupees, my lordship, notification and all. That's the
So according to you, the remaining component, whatever it is, the
owner should,
employer should pay.
Yes, my lordship.
Yes. That's the only ground.
Yes, my lordship. Age and the income assessment, my lordship.
How it is come to that?
Age showing in postmortem report is 57, my
So
lordship.
13,000 into 128 point. What should be the factor then?
My lordship.
What should be the factor then if it is 57?
But as per the Employee Compensation Act, section 12, my lordship, the interest part should pay employer.
What interest part?
Yes, my lordship.
You're saying that we have to take the age at 57. So what should be the change in the calculation?
It should be 8,000.
Relevant factor has to be.
What is the relevant factor? Take the act.
Employees compensation.
Say you are liable to pay 8,000.
Correct, my lordship.
Income is who appears for the employer.
Yeah, claimants claim that he was earning 15,000 rupees per month.
No evidence.
Exhibit R2, the document payslip produced. For 3 months, payslip is produced. As per the payslip, he was working under the respond number 1 and 2. He was working under respond number 1 and 2 from the year 2016. Accident occurred on the year 2018. As per payslip, it was 13,000 rupees per month. But I'm delaying this judgment since there was no amendment for enhancing the section 4. There was no, as per section 4 of
No, under this Employees Compensation Act, when there is evidence to show that the income is so and so, we should take that without respect of the
For
notification.
liability is only for 8,000.
Your limited liability is as far as that whatever the notification is, 8,000. The remaining amount the owner has to
Yes,
pay.
ma'am. Correct.
We will take 13,000. We will take 13,000. The remaining owner will have to pay.
the owner is not before the sound of the court.
Why? Where did he go?
It was served, my lordship.
Who is he is respondent number? Respondent number?
Harish Enna.
Respondent one.
Harish Enna.
Respondent 1 to my wife and children and son of the deceased person.
No, before this court.
They are all served.
1, 2, 3 are the family members. 4 are family members. 5, maybe 5 and 6. 5, 6 and 7 are they served?
Assistant General Manager. A post.
They are all served.
Yes, ma'am. All are served.
All are served. What is the judgment? One. We can't ask them to pay beyond what is contained in the agreement, the insurance policy.
The policy was enforced.
Huh?
The entire liability insurance has to indemnify the owner. In order to shift the liability on the owner, there is no liability on the owner. The entire liability is liable to pay to the claimant.
What is this? Why you are relying on this judgment?
There is a proof for income more than what is the notification prescribed.
Let's see which paragraph.
Paragraph number 11 and 12.
Any judgment of the Supreme Court?
Supreme Court. Another judgment of the court, not Supreme Court, some another high court.
Another high court.
Madras High Court. I will find out on the subject.
This is smart after vacation at the request of counsel, the respondent claimant. Yes, next.
Cell number 17. Cell number 17. Renuka HR. Our appellant MV Maheshwar. Cell number 17. Renuka HR. Our appellant MV Maheshwarappa.
Lord, my appeal is for my lord on the issue of negligence, my lord. My lord, the place of accident, my lord, is a bus stand, my lord, and the claimant, my lord, it's a case of injury. The claimant, my lord, tried to, my lord, enter the main road, my lord, from the cross.
Paragraph 7 is discussion itself starts at para 10.
Yes, my lord. Yes, para 7, my lord. In order to prove the case, the petitioner has given her evidence PW1 by filing an affidavit in lieu of her examination in chief and deposed, reiterating the contentions in the petition. The documents exhibit P1 to 117 are marked during her evidence. The veracity of her evidence has been tested in the cross-examination. In the cross-examination, petitioner has categorically denied the accident has taken place due to her fault. Counsel for the second respondent has cross-examined with reference to traffic rules to be followed while crossing the road. Further, the counsel has cross-examined the PW1.
Where are you reading?
My lord, I'm reading para 7, my lord. Sorry, page 12, my lord. Page 12, in page 12, para 7. My lord, this is MVC 935, my lord. 9.
You are reading a wrong bundle. It's MFA 5982.
Huh? So sorry, my lord. I think I've got a wrong file, my lord. Can it be tomorrow, my lord?
Oh, tomorrow give some date. Yes,
It's 1410.
yes.
Cell number 18 urgent. Cell number 19. Cell number 19. Gurudat K.
I appear for the
Correct.
appellant, my lords. Kindly grant time after vacation, my lords. After vacation, any date may be given, my lords.
Case of injury.
Case of injuries, two vehicles are involved, the liability is apportioned between the two.
List is matter after vacation. Yes, next parted matter.
Parted matter. Serial number 20.
Madam, serial number 19, madam.
20.
20.
19 after
After vacation, yes. Madam, I am for the appellant in serial number 20.
Number 10 of the appeal memo, my lord, it is stated that they have produced document 1 and 2 respectively. But it is
Are not served on the counsel for the claimant.
My lord, along with the appeal memo, we have sent it, my lord.
He says it is not received. Please send. Please delete from parted list after vacation. Yes. We will see when the, if you want
It is
to.
their own. It is their own document. I don't know why he is asking. It is their own document.
In the second list, any passovers?
First and
Second list passovers.
second list passover. The second list passovers. Cell number 1. Cell number 1, second list passover matter.
Yes.
Yudha.
Yes, I appear for the appellant.
The case of injury or death.
On negligence as well as on quantum, both have questioned, your lord.
Where is the other side? There is no representation on respondent side. No representation on respondent side on call. On several occasions, there is no representation on behalf of the respondent. And even today also, both in the forenoon and afternoon, no representation for the respondent. List is smarter. Give some date. Delete from the caption dismissal.
1510.
Yes.
Number 2. Mohan Chandra.
2, I appear for the respondent, my lord. Appear for the respondent, my lord. Respondent is very seriously suffering with the kidney ailments, my lord. Weekly twice he is undergoing dialysis because of this problem.
My lord, employer's appeal. Challenging.
There exists the relationship of employer and the employee between the respondent and petitioner. Let's read that.
My lord, fact of the case is.
Come to paragraph number 16 and read.
16. The PW1 has asserted that he was an employee under the respondent and was working as a welder in the Ganesh Engineering Works, Unsuru. That on 4/11/2017, when himself, Nawaz and Madhu, instead of Madhu, Sudeep, were working on the ground area during the course of roofing work. All of a sudden, a welding machine belonging to the respondent, which they had taken for the purpose of doing work of, as stated supra, fell on the left arm of the prisoner from the roof and he sustained grievous injury to his left arm. It was taken place as the respondent had not provided safety measure for the prisoner as well as to other employees. Therefore, it is only due to the negligence of respondent for which the accident has taken place. Due to the accident, the prisoner has got injured on his left arm and he took treatment by spending huge amount and he has suffered permanent physical disability. cross-examined by 17 pair. PW1 and 2 were subject to cross-examined by the respondent. During the course of crossing, it is suggested to PW1 that Mr. Nawaz undertakes the contrary work. He takes the worker to the concerned field for the purpose of work. The person PW denied the same and answered that they work in the workshop directly under respondent. Answered that they work in the workshop directly under respondent. Whenever it is required, the respondent Ganesh sends them along with Mr. Nawaz to the field for the work. Though it is suggested to PW1 that at the time of the accident, the person was working in Surya Engineer Works, but the same has been denied by PW1. This aspect of the matter has found place to come to the light only during the course of cross-examination. Observe there is no pleading on behalf of respondent in this regard in their objections. Therefore, this aspect of the matter cannot be considered. Further, during the course of cross-examination, it is suggested to PW1 by the person and his sister. Counsel for the prisoner received ₹40,000 but did not sign the stamp paper prepared by Mr. Nawaz. But even this suggestion made to PW is again without any pleading. PW has clearly denied the same. Though the respondent urged before the court that bond paper was prepared pertaining to the amicable settlement between prisoner and Mr. Nawaz, but no such document has been produced before the court. Though the respondent have disputed the name of the father of the respondent, but even the substance that aspect the matter, the respondent has not produced any document before the court. There it appears that just for the sake of taking defense, the respondent raised this point.
Come to paragraph number 22.
RW. Though the respondent got exempt Mr. Nawaz as RW2 and Mr. Madhuchandra as RW2, but no document have been produced by the response to show that the person was working under Mr. Nawaz and not under respondent. Admission of RW2 with regard to his testimony in the criminal case as PW3 before the court of Principal Senior Civil JMS Court Unsur clearly goes to establish that there is no dispute with regard to the relationship of the person and the respondent, and that the action took place during the course of the employment at the time.
What is this?
Because
what is this?
This is the document is not marked, but I examined one Mr. Nawaz. He has categorically admitted that on the alleged date action, he directly taken the work from one Mr. Madhu, roofing worker. At that time, he has paid the salary to him. Even the owner of the house also examined on my behalf to prove the defense. He deposed before the court that I am interested in enter.
You are the owner of the premises.
Madhu is the owner of premise who has given entrusted work to Nawaz to house roofing work.
What is the observation of the court about the evidence of PW3 in Principal Senior Judge and JMC Court?
Because it is a criminal case, but the judgment was not marked in this case.
You know, I'm asking you because you are a party to that.
Yeah, because I was acquitted in that case.
You might have been acquitted.
Yes.
We have given, as per this, what has been recorded at paragraph number 22, court has observed that with your deposition before the said court, there is no dispute about the employer-employee relationship.
I denied in the said case. Your lordship can see para 21 of the judgment, respondent has not denied. Which I have denied. But the court has observed I have not denied.
I am not on para 22. I am on para 20. Not 21, 22.
Criminal case also, I have denied the same.
What do you say?
Lord, even your lordship may kindly see the evidence of PW2 the doctor, my lord.
We will not look at the oral evidence.
No, that is one affidavit filed by the doctor PW2, my lord, disability certificate. Your lordship, it is in the document. Your lordship, it is in the document.
What
Chief
it says?
affidavit filed by the petitioner side, that is Dr. PW2. Dr. Shobha HP, Associate Professor in Orthopedic. That is disability certificate issued by the doctor. There it clearly says, patient came to self while climbing stairs at working office. At working office, he sustained pain and swelling on the arm. Again at para 1, 2, 3, third. Later, fall of heavy machine on his arm while working at working place.
Which is a working place?
Working place at Ganesh working place. But
What is the evidence for
Ganesh,
that? Observed so many things without any basis. There should be some basis. What are the exhibits that are marked? Please come to the award, to
Yes,
the annexure. What are marked? Exhibit P1 FIR, P2 complaint, P3 final report. Where is this final report? Take exhibit P3.
Yes.
Read this. This is not exhibit P3, read it. What it says? Where is the charge sheet? Is it marked?
Mark.
Where is charge sheet? Marked as?
Exhibit P3.
Exhibit P3 is not the charge sheet.
Yes, charge sheet. Yes. Final report. Antima Varadi.
Charge sheet is not Antima Varadi. Final report is different, charge sheet. What does it mean? Tell me in English.
He is standing down and the smell is going from very
No, ultimately, what did they say? Not the contents. Ultimately, what is it?
and it is ultimately that because of welding machine falls.
He sustained
He
injuries.
sustained injuries.
Mm.
Because that owner cautionary measures while doing
Charge sheet is filed against him.
against yes. You see in the column number 12, the person was shown in column number 12.
What is his name? Date of accident is?
4/11/2017.
Huh?
4/11/2017.
When was the report given?
Final report filed on
FIR. Look at the
one
FIR.
1/2/2018.
1/2?
2018.
Yes.
yes, Milord.
Nothing on record to show what is the connection between the accident, where the accident had taken place, what is the relationship between the parties.
I'll one a short date me again. I'll search and I'll place before your lordship, Lord, because I have some confusion.
This matter after vacation, at the request of land transfer the claimant. Yes, any pass also list 2?
In list number 1, list number 3,
Yes, one pass out.
one pass over. Yes, ma'am.
Dakshin Kannada. He is saying just he'll verify with the concerned police station. Kindly, it may be habit on Monday, my lordship. Is on
But tell your commissioner when there is an order of the court.
That's what he is also not aware, my
when
lordship.
when it is an order of the court, when it is communicated, whoever has requested for opening of a LOC, it is their duty to see and take immediate action. If they do not take, they will be taking the same at their risk. They'll be doing all this at their risk. Tell the commissioner that this will be viewed very serious.
I apologize, my lordship. I have communicated the same thing.
Leonard, now what about, now it is already, first number one is instructions about why it is not communicated. Number two is, now it should be immediately communicated so that it would make it easy for him to travel.
Please, my lordship.
Leonard, Garnal Peter submits that. She has already informed the same to the
Commissioner Police of Dakshin Kannada.
Commissioner Dakshina Kannada, and she would be getting instructions by Monday. The Garnal Peter shall inform to the commissioner again about this order, the interim order that is passed by this court, where the lookout circular is suspended, and shall see that there will not be any hindrance for the petitioner to travel. This is matter on Monday.
Cell number.
Let him withdraw. I have no objection.
This, as per the order passed by this court, the petitioner has deposited an amount of rupees 2 lakhs, and the respondent is at liberty to withdraw. Yes.
Cell number 7.
May I request, my lord, only one endeavor. May I request for hand delivery of the operative.
Yes. Next.
Cell number 7.
Appearing for petitioner, my lord, requesting to matter may be held on Monday, and request to
IA number 4, I'm withdrawing it with liberty to file a separate petition.
They are not pressing for IA number 4, and they
Lord-
have filed a memo seeking to withdraw the prayer as far as IA number 4 is concerned, and the petitioner undertakes to file the amended copy
I
of
shall
the
do that,
prayer.
my lords. I shall do that. I shall carry out the amendment right away. The urgency is the interim prayer.
Yes.
My lords, the operative portion is at page number 32. Reasons are recorded in page number 30 and 31. My lords, this is a petition by the petitioner mother. My lord, what happens is an application is filed before the trial court seeking visitation
Number
rights.
3 and 4. Visit the child on every Sunday from 10 a.m. to 6 p.m.
Well, that was not sought for. That was not sought for. The prayer was only for the ensuing Dasara vacations. The prayer was very limited. The trial court goes well beyond what application has been sought for and has granted for all vacations.
Why the court has no power to mold the
I'm not saying that. I'm definitely not stating that, my lords. My contentions have not been recorded. The documents that I've submitted to portray as to, my lords, I know, my lords.
Interfere with this order.
Please, I'll say, my lord. The reason is, my lords always has been of the opinion that a bad husband might not be a bad father, but annexures, my lords, if I may take my lords through to, because he even comes to court under influence, my lords. That is the whole problem here. And also, my lords, if I may be permitted to take your lordships to all his, it starts from page number 147, please. Consuming alcohol in the presence of the child. I have videos. I shall in fact play the videos as well in front of before your lordships. Page number 147 and 148.
The photos we have seen so many.
My lords.
It's somewhere there you.
My lords, but 6 hours, my lords, every Sunday, my lords. Then when will 8 hours, my lords, every
that you come to that
please,
point.
8 hours every Sunday, my lords. The mother ultimately
What is
will
the
not.
age of the child?
3 years.
My
Every
lord,
Sunday, 8.
If I may.
She is not even on caveat, my lords. Notice has not been issued in this case.
My lord, I've already filed my wakalat today, my lord, and I have not received copies of the.
Do the wakalat now on the coming Sunday. The father can exercise the visitation
Lord,
between 10 and 12. This is matter.
My lords,
My lord, if I may,
Saturday?
if I may kindly.
Saturday? In
Saturday.
in Bangalore, there is a play area in Bangalore Meditation Center on the 4th floor, which is really well.
If I may kindly make a submission, my lord, the respondent father is settled in Haryana, my lord. We've clearly intimated that if we are ever going to make that physical visitation happen, one day prior, the plan will be completely communicated to them. Because the father itself is in another state, it's not possible, physically possible for the father to come every Sunday. Despite that, we are willing to, per the order of the court, we are supposed to communicate the plan. We've already intimated them. If we ever plan on coming to Bangalore and visiting the child, we will intimate it prior. There is no impediment from our side in communicating exactly where we'll take, how the entirety of the plan, my lord. All I'm saying, my lord, is in this situation, if an order is passed whereby this visitation rights are taken away, the father has not seen the child for the past 1.5 years, my lord. only for 10 minutes on the date of the child's birthday in the police station, the father met the child, my lord. In the lower court, the authority, the precedent that I relied on is the Jyoti Priya case, my lord, that this honorable court's division bench had passed, in which it clearly, one of the,
Don't mislead.
apologies, one of the guidelines is very clearly that the rights of the parents are not paramount when considering interim applications. Even so, my lord, I will advance my detailed arguments once I receive the copies.
This Sunday is coming. That's
Yes,
what,
ma'am.
where is the time to hear your
Lord,
detailed arguments now?
My lord, this Sunday we are not exercising our physical
Then
visitation
we'll have
rights.
it on Tuesday.
Just
May I please request
may I
only
please
one
request-
indulgence, my lords? If they're not exercising, let them in fact place it on record, because what happens is, my lords,
It is submitted by
this
the
Sunday,
council.
this Sunday we are not
I
exercising.
understand that.
My lord,
Then counsel for the petitioner seeks an interim order. It is submitted by the respondent that this Sunday, the respondent is not visiting the child. And it is submitted that she'll come up with her objections. This is matter when
my lord, one more humble submission, my lord. Until they move a writ application, a writ petition, so far as IA number 4 is concerned, the child may be allowed to, the father may be allowed to access the child through video calls, my
I
lord.
have no objection. That will be done. That is.
Obliged. It may please be recorded also, my lord.
the father may permit it to have access to the children by way
As
of
per the-
child by video call. Land counsel appearing for the mother submits that they have no objection. Hence, the father is permitted to have a video call with the child at what time?
It is about 15 minutes. A 3-year-old child, my lords. Your lordship
My lord,
has so many
a
matters.
minimum time, as far as the child will be there, the court has given
Let it be on the-
between 7 to 7.
Day. Which
My lord-
date?
My lord,
day?
every day is the order, my
My
lord.
lord, every day is granted. All that, probably, my lord, all that I can say is let him talk. We are not denying, my lord. Thrice in a week or whatever. The problem is every day 15 minutes. You cannot pressurize a child to sit in front of the computer and
We are
talk.
not
That is
asking for
possible.
pressurizing the child
Let
at
it
all.
be
There
according
is
to
an
the convenience of the
existing
child.
order, my lord. All we are asking is the existing order be
I leave it to your
followed.
lordship.
From today
Yes, my lord.
till Tuesday, the father can talk to the child every day for 15 minutes.
Obliged.
This is the matter on Tuesday.
Obliged.
So and so submits that. She has instructions to file wakalat, and also the respondent had appeared online.
Obliged.
Party.
Obliged.
Yes. Hmm. Yes.
Cell number 13. List number 1, pass over cell number 13.
And fruit stall he is having in a large scale, my lord. He is a wholesale vendor. He is having a big shop in Central Market, Mangalore, near Central.
Assertion.
He's
What is the
60,000 per month
What is the
minimum, my lord.
material on record?
Lord,
What is the material on record?
I have mentioned it in my assets and liabilities. It has remained,
Mentioning is
it has
not
remained unopposed.
Mentioning is not sufficient. Yes, filed his statement of assets and liabilities.
He is not.
Please, my lords, I have filed, I have
I
submitted
have-
the
I
memo
have-
also, my lords. Memo dated, my lords, 7/8/25, my lords.
So it is a wholesale shop, my lord. Minimum 2,000 he earns per day. And he is having his own house in Kasba Bengre, as well as he is having a ration shop also, grocery shop.
In this case, how much is granted?
My lords, shall I make a one submission, my lords?
125, 8,000.
Other
TV actor, interim maintenance, 7,000.
7,000, my lords.
All put
Two
together,
kids,
it
yes.
is
It will be
15,000.
15,000, my lords.
He is earning 60,000 per month.
There is no
That's
evidence for that.
absolutely false, my lords.
No,
I have been not,
You
my
paid
Evidence-
Mr. Counsel.
In my evidence also I have stated, and it is not nullified.
lords, may I make a one submission, my lords? Previously, my lords,
It is
I could
only
not
ninth
pay the
step.
arrears. Then FAW was issued. I was arrested and I was produced before the court. And after
Arrear-
payment of 5,000, my lords, then I was released, my lords. If I was earning, my lords, 60,000 rupees, my lords, there would be no case of arresting me, my lords.
Arrears are paid on 7/8/25, my lord. After coming here,
What arrears are paid?
50,000.
No, entire arrears are paid.
No, my lords, entire
no, my
arrears
lord.
are not paid, my lords.
No, 1 lakh something is pending. 1,17,000 is pending according to him. Recently 50,000. He gave me the copy today.
Agreed with her. Award fasting. Agreed with her.
He's having
What
his
is
own
past?
house also.
My lords, may I make a one submission, my lords? I'm aware of the facts, my lords. I'm liable to pay the maintenance, my lords. But the only my thing is, my lords, that let the two children.
Wife along with 2 children. The wife is before this court. The wife has filed a petition seeking maintenance of an amount of rupees 5,000 each to all the 3 petitioners. It is a case that husband is an able-bodied person and doing vegetable business near Central Market, Mangalore, and earning more than 2,000 per day. The husband, it is a case of the husband that he is working in a food shop and now he has quit the job, and in domestic violence case already an amount of rupees 7,000 is granted by the court. That itself he is not in a position to pay. The tribunal, the family court by order, the family court had ordered the maintenance, observing that the respondent husband has not shown any income in his affidavit, and that as it is observed that respondent is an able-bodied person having no ill health, and he is in a position to earn and maintain the petitioners and granted the amount. Then counsel submits that as he is not having is not doing any job, and it's very difficult for him. Is not doing any job, and it's very difficult for him to pay an amount of rupees 15,000. And counsel for the respondent wife has reiterated the grounds that are stated, and it is submitted that the husband, in spite of having the means, is not taking care of the children and the wife, and he is staying in his own house, and it's difficult for the wife to maintain the 2 children and herself with the meager amount that is granted under the Domestic Violence Act. Hence, the present application is filed. They are living in a rented house. 3 people have to support themselves.
They're not living in their rented house. They're with their maternal house.
The petitioner, husband, is living in his own house. The respondents are living with the parents, with her parents. Even if assuming that is a daily he is seeking out his livelihood why when he is a able-bodied person, why he is not working? No explanation is forthcoming. As already an amount of rupees 7,000 is awarded by the in the domestic violence case, this court deems it appropriate to modify the order of the tribunal family court by balancing the interest of both the parties by reducing the amount of 8,000 to 4,000. Accordingly, the petition is partly the petition is disposed of.
Obliged, my lords.
Bill number 21. Suresh Babu BN petitioner Ganesh G.
The matter was listed before your lordships on 11th, my lord. On 11th, noting the absence of the respondent, the interim order got extended and the matter was adjourned to November 1st week, my lord. Lord, now subsequently, my lord, my learned friend has served me a copy of vacating stay application. For that, I may kindly be permitted to file objections because he has taken up new plea, what it was not there before the trial court. And also he has produced.
I made it very clear.
Please.
We will not look at any of the pleas that he is taking. We will only confine to the impugned order.
Please.
We will only confine to the impugned order. Please come.
Also, today the matter was also set down there for cross-examination. What I would request your lordships is kindly direct the trial court, interim order arrangement, what it is there been, it be continued. Let the trial court decide the matter within an outer limit. Lord, it is 2022. Plus,
already violated this honorable court order, my lord. I have filed.
Polar.
Yes, Your Honor.
Kolar we can give a direction because Kolar.
2022 matter, my lord, even, my lord, one
My
minute.
lord, already
Even, my lord, the
they have
learned
violated this
trial
honorable
judge.
court order, my lord. I have
My lord,
placed before this honorable court.
If both of you want to argue,
No,
I can't help it.
even the trial judge today requested him to conclude the cross
We
examination.
will see what is
So that the
what is the interim order granted.
Lord,
by the
interim
court?
order, what it has been granted was,
Yes.
Lords, following your Lordship's earlier judgment, where your Lordships has directed the father to visitation rights. Lords, may kindly come to page 82. Lord, this is the order in earlier occasion your Lordships has passed. Page 82, my lord.
First of all, before going into this, let me look at this order. What is the order?
Lord, here the same interim arrangement has been continued.
Let's see.
Lord, coordinate bench
IA
of this.
number, IA, come to page number 31 of the impugned order.
Lord,
The respondent is directed to keep present the child on every Saturday at 11 a.m. except on general holidays before the court, and father is permitted to take the child to his interim custody from 11 a.m. to 4 p.m. and shall produce the child before this court at 4 p.m. to 4:30 p.m. So what is wrong with this order?
Lord, what my respectful submission was, the Lordships has also interacted with the parents as well as the child. Lord, my respectful submission is, till the child get acquainted with the father.
How many days it will take?
Lord, it is 7 years.
No. When was the earlier order passed?
Lord, the earlier order was passed by this honorable court on
December
7th August 2024.
7. It is after a year. So this matter in outer limit of 5 months.
Please, not 5 months, my lord, because already 2022 matter, respondent has taken several, the petitioner has taken several.
It is now.
No, the stage is today, he was supposed to cross-examine
It will take outer limit of 5 months will correct.
not 5 months, my lord, 3 months at least, my lord, because.
With the order
Can,
passed.
my lord, can I make one
2022?
submission, my lord? Please, my lord. My lord, after passing of this honorable court order, interim order, my lord, after.
I am vacating, I am
definitely.
allowing, I am dismissing the writ petition. No further arguments are required in this. I'll ask the court to dispose of the matter. Agreed with the orders passed in.
Because already she was violated the order of this honorable court order, my lord. I have placed before this honorable annex E and F, my
your
lord.
own method. Agreed with the orders passed in I number 9 and GNWC number 9 of 2022, whereby the family court had granted, as directed the mother to present the child on every Saturday at 11 a.m. except on general holidays before this court, and the father is permitted to take the child to his interim custody from 11 a.m. to 4 p.m. and to produce the child before the court at 4 p.m. to 4:30 p.m. and hand over the child to the wife, to the mother. The mother is before this court. Then counsel appearing for the mother submits that earlier this court has passed an order, and as per that order, the visitation shall continue. It is submitted that the father shall develop the attachment acquaintance with the child, and straight away such an order cannot be passed. Learned counsel appearing for the respondent submits that even the interim order that is passed for this court is not the mother has failed to comply with the same. It is submitted that the court considering the application that
Third Saturday from 1 a.m. to 5 p.m.
third Saturday from 1 a.m. to 5 p.m.
5 p.m. in Mediation Center, Family Court.
In the Mediation Center, Family Court. This order is passed a year ago. Now the present order is passed. This order is granting the interim custody from 11 to 4 p.m. on
Saturdays,
on every Saturday
except on general
at
holidays.
11 a.m. except on general holidays. The court at first instance has passed an order where the visitation is before the court. Then the court had passed an order where the interim custody is given to the father. The submission of the counsel for the mother that it has to be taken slowly, this court is not able to appreciate. Court had rightly passed an order earlier, and once the father started exercising it, now this order is passed. This court do not find any other reasons to interfere with this order. Next para. The GNWC is filed in the year 2022. The family court shall expeditiously dispose of this matter with the outer limit of 4 months.
Your Honor, may permitted 5 months. 5 months.
What is your problem?
Because, my lord, earlier the family court was
Lord, this-
granted the visitation rights
even
and
a
access
letter has been
overnight
sent.
custody in 10 days. my
Even
lord.
If a party is asking for more time for disposal, then we have
learned
to.
family judge has sent a letter to this honorable court because this is the oldest matter which is pending. This is due to the non-cooperation of the respondent council filing an application one or the other way.
My lord,
Within 4
she
months,
herself has not been cooperated before the trial court,
shall
my lord.
not grant unnecessary adjournments and make sure that the matter is disposed of as expeditiously as possible.
Please, please.
Yes, next.
My lord, and visitation rights also she will cooperate and may kindly direct there because when she was with visitation rights we have exercising during that time she was obstructed, my lord, in mediation
Then
center. my lord.
what is the procedure that is available?
So because
Nagraj KR for petitioner. Krishna Swami K.
Respondent in this case.
Yes. There is no representation on behalf of the petitioner, and an order is passed that if the counsel fails to appear before the court, costs will be imposed. In spite of that, the counsel has not come before the court. It shows the conduct of the client and the conduct of the counsel, and that he has no respect to the orders of the court. Ultimately, for not appearing before the court, he is answerable to his client, and as on the lapse, as there is no representation on his behalf, this petition is dismissed for non-prosecution.
Cell number
Yes,
2.
to-
Cell number 2.
Lord, I'm
Ravindra
filing the
Nath
memo
K.
for, this is the only, my lord, the direction which has been given to file a memo of calculation. How
Where
much
is he?
Lord, though the Lord, as per the order of this court, my lord, copy has also been served on the answer, my lord, the counsels who are represented before the trial court. Despite that, my lord, they are absent.
On several occasions, there is no representation on behalf of the respondent. List this matter as parted, delete from the caption for dismissal, and next date of hearing, even if there is no representation on behalf of the respondent, the matter will be heard and orders will be passed.
Lord, that memo of calculation may be accepted. That is what
Memo
it is.
of calculation is filed, and the same is taken on record. Yes, next.
Great.
Cell
Publish.
number 3. Cell number 3.
appear for the certified copies of entire order sheet in MC number, and also parties have settled their dispute in pursuance of that memo. My lord, your lordship
Yes,
kindly
to the
disposed
joint
of.
memo.
14/8/22.
There is a joint memo.
Joint memo.
Why is there? Close the window. Compromise, a joint memo is filed before this court, dated
14/8.
dated 14/8/2025. As on that day, the parties were present before the court. On the day, an amount of rupees 5 lakh.
5 lakh it is settled. 2 lakh
50,000 on that day,
50,000
an amount of rupees 2,50,000 is paid before the court, but the remaining amount of 2,50,000 they would be paying the same when the MC number 139 of 2025 is settled before the court. Hence, this court has adjourned the matter. Today, a memo is filed before the court stating that on which date?
On my lord, 23/8/2025.
On 23/8/2025, the remaining of a amount of 2,50,000 is paid. Learned counsel appearing for the respondent do not also submits that the amount is received in that view of the matter in the light of the joint memo dated 14.
Petition filed for enhancement, my lord, seeking enhancement of the maintenance, my lord. Whereas the trial court awarded only 5,000, my lord. That also the husband, respondent husband, is not paying regularly, my lord. And this petitioner, my lord, being a single lady, my lords.
What is the income?
My lord, income of the husband, respondent, my lord, approximately he is earning more than 90,000 per month, my lord, because two network towers are established in.
They have no income. They are bonded labor. I
No,
file
they
a
have.
affidavit in favor of the respondent. Please, take on the card. Affidavit.
What is this bonded labor?
They have no proper income to the respondent.
Take that.
Dinaguli Naukara.
My lord,
No
kindly
proper-
see.
It is abolished long way. Why is he doing bond?
My lords, one submission.
Hmm.
My lord, in the cross-examination itself, my lord, they have already, my lord, deposed before the honorable court, my lord. In one way, they say, they admit that they are having a chicken shop and the property, agricultural property, more than 3 crore.
Still number 5.
Memo is filed seeking acceptance of paper publication. In respect of
petition,
respondent is accepted. Notice to respondent is held sufficient. Admit is accepted. Notice to respondent is held sufficient. Admit post of final hearing.
Still number
Admission,
6.
Admit
Please.
post of final hearing. In the name of the party. S6.
6.
Petitioner, my lords.
SV Prakash.
Time, my lords.
Hmm?
I request for a week's time, my lords.
Why?
I have to get instruction. They have filed a IA for vacating stay. They have not served copy to me, my lords.
My lord, serial number 6 is with respect to they have filed a memo for retirement, my lords.
That's filed by.
I'm filing the memo of retirement.
Where is that?
Respondents did not communicate this. For the further prosecution.
Where is the acknowledgement?
Already served some.
Huh? When is it served?
59, some.
15?
9.
I don't find it. Where is it?
59. Attachment, along with attachment.
No such person. Hmm. Then counsel for the respondent shall file a memo indicating when is it sent, when it is received, if received, when it is received. After vacation. Yes, 8.
Still number 8. Still number 8.
Paper publication.
Huh?
Paper publication notice have been taken.
Yes, yes. Memo for acceptance. Yes, print the name of the party. Notice to so and so is a name. Where is order?
Yes, my lord. Order is, my lord. I have attached it in my memo also, my lord.
No, let's see what is the order of this court.
Please, my lord.
Court as per the impugned or trial court had discussed about the facts of this case. petitioner shall pay maintenance of an amount of rupees 6,000 per month to the wife, and the arrear had to be within a period of 8 weeks from the date of the receipt of the copy of the order. That is 9/7/2025.
Yes, ma'am.
Now, where is the receipt?
No, my lord, receipt is, my lord, I have received the copy on 21/7/2025.
What copy?
The order copy, my lord.
It doesn't matter. When did you receive?
21/7/2025.
How can the order be received after 20 days? Almost 15 days.
Yes, my lord.
Whenever you take the order copy, that is the date of receiving the order copy. Ask her when is it uploaded, this order is uploaded. RPFC number 132 of 2025.
132. Daily order petition. RPFC 132 of 25.
On the same date is uploaded.
Yes, my lord. And also, my lord, petitioner is.
No, if it is uploaded on the same day,
Yes, ma'am.
when will the 8 weeks will complete?
On 9/9.
Then?
Yes, one more submission, my lord. The petitioner is already paid, my lord, up to 2 lakh.
That we are not, to how much?
Yes, my lord. Arrears is, my lord, 2,22,000.
Where is the receipt to show that you paid 2 lakh
I have
20?
produced memo, my lord. Certified copy.
When is the date of order? Date of IA?
Yeah, my lord.
It's a final order. When is the date of petition?
Petition 18/6/2022, my lord.
18/6/2022.
22. Yes, ma'am.
This order is passed on 9/7/2025.
Yes, madam.
That's almost three years.
Yes,
That
my
is
lord.
36 months.
Yes, my lord.
36 months into?
36 months.
Into 6.
Yes, my lord.
Uh,
My lord, I have made it 39 into 6, my lord. Because this
39
is
into
6.
6.
That is 2,34,000.
Where is that?
But I paid 2,52,000 till today, my lord.
2 lakh?
52,000. 18,000 I have paid extra, my lord.
When is it? Date is important.
Yes, my lord. The last date of hearing is, my lord, I have produced it.
Because why would the court issue warrants against you if you have paid?
No, I am paying 12,000 per month, my lord. If the court is ordered for 6,000, I am paying 12,000 per month.
We are not on that.
Yes,
No, where is that warrant issue?
The page number 7 of my memo, my lord. Page number 7.
Where is the memo?
Now I produce right now, my lord. Page number 7, my lord.
Yes. Case called again on 3 p.m. Counsel for respondent has paid 12,000. Reports the receipt of the certificate. Since the respondent has not complied with the order of the High Court of Karnataka, the order of the stay will be vacated automatically. Hence, issue NBW. Where is your advocate to tell the court what is the amount? What did he?
It's aware, my lord.
It is
It's
aware. It is
Yes.
said you have not complied. That's why issued the warrants. Go to the court and tell that this is what it is. I have paid.
Please,
So the court will recall the warrants.
please, my lord. I have all the records that I have paid till today.
Tell the court, not this court.
Please, my lord.
Yes. Next.
Please.
Next. After vacation.
Cell number 10. Cell number 10. Trivik Ramesh.
Lords, I appear for petitioner. It's an husband's petition, my lord. Husband's petition, my lord. It's challenging the maintenance order.
Delay.
Delay, my lord, 636 days, my lord.
Let's see the delay, why the delay of 603 days.
Yes, my lord, what has happened, my lord? The petitioner is in financial crunch. Petitioner is in complete financial crunch, my lord, before making any
For
submission, my lord.
filing their RPFC, you don't have to pay the entire maintenance.
No, my lord, to approach the advocate, my lord, yeah. Actually, I want to place one document on record. Lordship may kindly see what the income certificate, my lord, is having only 80,000 income annually. It's not working, my lord. That's the reason he could not approach advocate, and
Today also it remains the same. About 2 years back and today also it remains the same. Now today he could come, he could have done it long back. On those grounds, we will not enter, we will not condone the delay of 2 long years. There should be an end to the litigation.
so some family disputes, my lord, he could not able to.
Litigation.
So some family disputes, my lord, he could not able to.
Whenever they want to come to the court, court will not allow them. There should be a reason for not coming to the court. I can at least understand wife's application for enhancement of maintenance, but not husband's case for questioning the order after 2 years.
Reason being, my lord, he has no financial means. There is nothing, my lord.
According to the respondent, 8,40,000 remains unpaid.
Take that.
On 19 February 2025.
Look at it. Look at his calculation memo.
I've received a copy, my lords.
The subject to condition that the petitioner pays deposit 35,000 per month to the respondent number 2, who is minor child, namely Anvay 3. Again, learned counsel for the respondent shall furnish the account. That is next para. The petitioner shall also pay the arrears of maintenance amount at the rate of 35,000 per month. If any amount already paid, same shall be deducted. In my case, from February 2025, I have been paying, I paid the last date of hearing, the payment of rupees 2,10,000 towards arrears of monthly arrears of maintenance. 2,10,000 by DD. And a sum of rupees 31,000 towards arrears of rent, after deducting a sum of rupees 1,78,190, which is been admitted by the other side. According to this, till 19/8/2025, my payment is done. Now next due is tomorrow, your lordship.
My lords, may be permitted to submit now.
Where is your calculation?
By memo of calculation, I put it.
Calculated from the date of.
My lords, the first paragraph itself,
From the date of?
From the date of order.
That's what arrears or that's how calculated.
Arrears must be calculated on that day.
In that case, calculation is arrears of maintenance is specifically made every month. We should pay 35,000 towards arrears of maintenance, and regular maintenance is 35,000. That is.
I don't think that won't be the order.
That
my
is
lords,
the order.
may be permitted to clarify.
1 minute. Let's see the order. What is the order again?
19/2/2025 orders, my lords.
Arrears are also at 35,000 is what is the order of the court.
Every month.
Every month. Not every month. It is not.
That is
the petition of arrears of amount at rate of 35,000 per month. That is whatever are the arrears.
Per month. Per month.
What is the maintenance that is granted?
1 lakh, my lords.
No.
Court has made it.
No, 70.
Whatever it is, court has made it 35,000.
Yes.
So, what is the order of the court is you should continue to pay 35,000 per month. Yes. Arrears also at 35,000. That is not per month.
I understand.
So, that is arrears will start from the date of the petition till now. That is at 35,000 is what is the order.
Yeah, because of his financial difficulties, he was permitted to pay every month, your lordship. That is the background of the fact. That was the background, your lordship. Because I am the new counsel. When I asked for the previous counsel, the background of this, when he expressed his inability to pay altogether, he was permitted to pay every month.
What we generally grant, we say so and so is reduced, so and so amount to be paid. Even the arrears also at so and so.
At the rate of 35,000 per month. Yes.
What is the
that was the background in he has expressed his difficulties. He was permitted to pay every month towards arrears.
No, I think both of you should seek the clarification of this order from the learned judge.
To pay every month towards arrears.
No, I think both of you should seek the clarification of this order from the learned judge.
My lords, it's clear enough, my lords. I feel like he's interpreting it
Can
another
I
way.
counsel for the?
I maybe we will submit just
I
for 1
will-
minute, my lord. I mainly submit just for 1 minute, my lords. I'll explain as to why I've come up at least to 8,40,000 rupees.
Because you calculated 35,000 from the
From
date
the
of
date of
petition
impugned
till
order,
now.
because it's clear to see that the order specifies that
Counsel
they'll
for
have
the
to pay
petitioner
arrears as well.
submits that. In the interim order granted, it is as considering the plight of the petitioner. The court, the same is disputed by the land counsel for the respondent. The counsel for the petitioner shall seek a clarification of this order. Yes,
One submission. And
this is my
so far as
clarification.
My lord, the interim order
this
now
file-
may not stand extended then, my lord,
It is-
because it's your lordship's order is what I would like to rely upon, dated
is paid. Tomorrow is-
23/7/2025.
Tomorrow is the due date, 19/9.
23/7.
List this matter on Friday, next to Friday. By the time the petitioner shall seek the clarification before the learned judge.
26/9. Serial number 12,
Much obliged, my lord.
Gagan Raj.
Notice.
In the
Serial
earlier
number
occasion,
for
this
admission
honorable
matter.
court was rejected my petition for dismissed for non-prosecution. I filed an IA for condoning the delay for 14 days and
Why you were not there?
3/6/2025.
Why you were not there?
My lord, because I am not suffering from fever, my lord. That is the reason I am not, my father, that is the reason I am filing.
IA number, it has become routine, IA number 2 of 25 is filed to recall the order dated 3/6/2025. And IA number 3 of 25 is filed to condone the delay of 14 days in filing the application. Considering the reason stated, the delay of 14 days is condoned in filing the recalling application. Consequently, I number 2 of 25 is also allowed by recalling the order dated 3/6/2025 and the petition is restored to file. Yes,
And maybe 2 weeks,
yes, notice to the respondent.
please, ma'am.
Serial number 13, for admission, Shrikant Patil K.
You are for petitioner, my lord. Seek time, my lord.
Adish.
The order passed your lordship deposited 50% is not yet deposited.
You deposited, my lord. You counterfile.
Give it to
Serial number 14,
File my calculation your lordship by the next date.
No, that's why I said you will get instructions. Yes.
Meenakshi. Serial number 14, Meenakshi K for petitioner.
We have challenged the order of the court below, my lord. Court below has ordered 6,000 rupees maintenance for child, my
We'll
lord.
see these matters next week. All
Date
the
may be
matters,
given, my lord.
give a date. after
Opponent, my lord, he has not even paying the maintenance to the
This
child, my lord.
RPS is 17
We have filed execution
Until
petition, my
tomorrow.
lord.
and remaining
So
matter.
he is working in police department. He has not paying a single rupee, my lord.
Yes.
Even for the child also, date may be given, my lord.
Yes.
My lordship.
My lord, kindly date may be given in.
Will be given, Mr. Counsel.
List number 5, list number 2, they have done Monday, tomorrow is nothing but.
My lordship, report may be given to move the memo before the vacation bench, my lordship.
Of what?
Um,
Of what? It's there tomorrow. Court is there next week also.
Please, my lordship.
Huh? Which case? You want to move? it?
17, my lordship.
Huh?
17. I heard, sorry, my lordship, I heard that it after vacation, that is the thing I.
No.
Please,
17 is, I said all 25 matter tomorrow it will come.
Please.
All other old matters will come after vacation.
Please.
My lordship, serial number, list number 5, serial number 4, my lordship. Kindly have it on Monday, my lordship. It's death.
Ask the court officer the dates. Yes.
Serial number,
One less and it should not be more. Whatever date only.
serial number 19, third list. Kindly be taken up tomorrow or on Monday.
Any urgency in that?
Parted.
Next week, some date. Any signatures?